Yes, sir.
Lord, very unusual situation. I have to leave for Delhi after some time.
Ah,
Item 13, 14, and 15.
okay.
My lord, if I am, I'm here till 12 o'clock, my lord. If it reaches, my lord, perhaps I will do. Otherwise, my lord, my junior will make a mention.
Okay.
I asked for an accommodation from the other side.
Ah.
They refused. That is
All
why
right, we'll try.
I am in a soup now.
We'll try. What time are you leaving? 12.
But before 12 or by 12, my lord.
We'll try. We'll try. Yes, sir. 27. Mr. B. Sharma, learned counsel for the petitioner, has submitted that the order has been complied with. We'll stop. Accordingly, the contempt case is closed. Yes?
Item number 38.
38. Ah.
Response number 4 to 6.
At the request of the learned counsel for the petitioner, who submits that a rejoinder is required to be filed in the matter, place this matter again on
And any date of May.
May. Right? 7th of May.
Deeply available.
23. Yes. At the request of the learned counsel for the petitioner, lists the matter again on
23.
25th of March. Yes.
May Tuesday, Lordship. Lordship, in respect of item number 34 and 35, Lordship,
Hmm.
the Lordship has granted us liberty to pray for an upgradation. Lordship, I pray accordingly, Lordship.
34 and 35.
34 and 35, Lordship.
Okay, we'll try.
Lord, at 2, my Lord, may I pray? Lordship.
Ah, okay. At
I'm
2
so
we'll try. Item 34. Ah. If it is, they file some
They have filed an IA, Lordship,
Ah.
only for an extension of interim order. Lordship, let it be on
Ah.
record, Lordship. Lordship.
Okay.
Lordship,
Call
in
for-
regards to item 25 and 26 with the consent of the other side and praying for an adjournment, Lordship.
At the request of the learned counsel, paying for the respondents,
PNRD. On behalf of the municipal.
PNRD. List this matter again on, when do you want it?
Lordship, after 3 weeks. 25, 26.
20 April,
Lordship, similar prayer is for item 31.
31.
Lordship,
For further hearing, nothing doing.
Lordship, I have circulated an adjournment slip yesterday.
Ah,
I said,
we'll release it from Pathat to go into voting.
31.
Why? When do you want it?
Lordship, can it be on 24th of March?
Why?
Lordship,
Why not on Friday?
Lordship,
What is the difficulty?
Mr. Kumar is not well, so he has been on bed rest for a few days.
At the request of the learned counsel for the respondent, release this matter again on the 9th of April. Matter will not be treated as part heard. Yes. 33. At the request of the learned counsel for the petition. This is 2017 matter. Huh? We'll take up the matter. We'll see what is to be done. Let the matter reach. Learned counsel for the petitioner, under instruction is submitted that he may be allowed to withdraw the matter accordingly. The writ petition is closed as withdrawn.
My record.
Huh? With the liberty to file afresh. Huh?
Record my presence.
Mr. A. Somo appears for the respondents.
Response number 4.
Respondent number 4, UGC. Huh? Huh?
PTC is the opposite main party of the.
Who is BTC? Where is BTC? Huh?
SC PTC is showing in the.
Huh? What is the matter about?
My lord, initially, my lord, the petitioner,
Huh?
he was illegally terminated.
Huh?
Thereafter, this honorable court had reinstated him, my lord.
Huh?
And after reinstatement order also, after
Hey.
6 years, yes,
List this matter before the bench. List with this matter before a bench without me. You should look into the order, sir, when it relates to the education department.
I am free.
Yes? Huh?
Actually, they have made.
Lordship, one thing, Lordship.
Hmm.
Lordship, a little accommodation, Lordship, we have misplaced our file, Lordship, sometime, Lordship.
Mr. Bhuyan and Council appearing for the Department of Higher Education
Lordship,
has submitted that the file has been misplaced and he requires an accommodation for the day. The matter is of 2020. Learned Counsel for the petitioner shall supply a copy of the petition to Mr. S. Bhuyan, Learned Counsel appearing for the Higher Education Department. The affidavit in opposition is to be filed within a period of 6 weeks from today. List the matter again on 8th of May. Give him a copy. Give him a copy of the writ petition.
I am proud to serve.
Yes. Huh?
Took time for filing affidavits.
Huh? Forget it, 2001, what is the matter about? Huh?
They're claiming 2 persons.
Huh?
Four and 7.
Huh? Tell us. Tell us your story. Otherwise, affidavits are filed. No affidavits filed. Who appears for the private respondents?
I am appealing for a respondent on 9 lot.
Number 9.
Yes.
Okay, and?
My service is provincialized.
Huh?
So we go over the entire facts of the, it was a disputed question of facts. He is claiming I am the headmaster and my service already provincialized.
Hmm.
Director already take a call to provincialize my service. That is also put to challenge.
Hmm.
That is also pending. So since Lordship as per the statutory provision, there is an alternative remedy. They should prefer an appeal before the authority. After provincialization, my service, that appeal is not filed also. And he is still aggrieved by the order of the director. So he has to first avail the remedy also of the statutory remedy. Disputed question of fact is involved.
Who will file affidavit? Huh? Not necessary. Their orders are on record. They have passed orders. Those orders are on record. They will repeat those orders in the affidavit. Huh? Why don't you say it at the first go? Why waste another 10 minutes? List this matter before another bench without me. You should tell this at the first instance. Okay. Pendas. Yes. Huh? Promotion. Yes. Tell us. Huh? Hmm. 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 এই ফুকন এটা হেৰি দিয়ক scroll টা দিয়ক after some time let someone from the GAD come. Yes. Huh? Ah. Did you lodge an FIR? Huh?
There is no FIR filed.
Huh?
After her submission for this life, I
Huh.
got some information on the RTI.
Huh?
That my lord, she is not even HSLC passed while she was appointed.
Huh?
And she was appointed in the year 1990. And at that point of time, she was undermated. So
Huh.
as per the act, my lord, she has to be appointed having minimum HSLC. That is the mandate under the
It
act.
is for provincialization.
No, but that is initial appointment in the school. So she was not even matric passed at that point of time. And he, in fact, madam, played some fraud, madam. She, madam, submitted document disclosing the fact that she passed her higher secondary in 2002. In fact, we got some documents under RTI which shows that she, madam, passed HSLC in 2000 and higher secondary in 2018. So this was, madam, misled, madam, by her, madam, while her service was, madam, not misled. The petitioner, madam, who is the, madam, second teacher of this, school, madam. Then, madam, I have annexed this, madam, appointment letter, you know, you find it at page 22. Madam.
This is the petitioner.
Yeah, yeah, is the petitioner.
Ha.
Next, next, two, madam, page 22. This is the appointment letter, madam. She
Ah.
got appointed, dated 28/02/2006.
Hmm.
So next, my lord, this 2019 data, my lord, data, my lord, of under DICE, my lord. It shows the, my lord, the, my lord, next page 24.
Hmm.
This is the, my lord, particulars of the teachers of that particular school.
Hmm.
That is, checking, my lord, Oruna Hazard, this is the, my lord, respondent number 5.
Hmm.
So, our, my lord, date of joining is shown as 1990.
Hmm.
That is year of joining Taluk Madam, 1990.
Hmm.
And immediately next to that, that is Mark 2, that is HSLC. So this is the document prepared, this is DICE data of 2009-2010.
Hmm.
So as per this file, she is a HSLC first candidate in the year 2009-2010.
How do you know the 2 is HSLC?
Madam, that is, below, down below, madam, this is, madam, indications are there, madam. Secondary 2, higher secondary 3.
Hmm.
And,
So
madam,
she is shown as an higher secondary.
higher second. She
Okay.
has been shown HSL. Yes, she has been shown HSL.
How?
She has been
2 is higher secondary.
3 is secondary.
Huh?
3 is higher secondary. Because
Oh, acha, so no, no, it's okay. Below secondary is 1. Secondary is 2. Hmm.
annual annexure 4, that is the one matter document prepared under the authority of that school
Ah,
by the headmaster. Your lordship will kindly come to, it's a type copy of this matter, page number 28.
mm,
If your lordship kindly have this matter, page 28 for the, moment matter. That, in the column 16, year of passing HSSLC. That is 2002, so for this, Boruna Harda, that is the private respondent is concerned.
mm,
So on the basis of this pilot, that she passed her higher secondary in 2002.
mm,
Accordingly, she got her service commissioned. In fact, my lord, we had some document under RTI,
mm,
my lord, the effect that whether she is really she is my lord, a candidate, my lord, passed her HSLC
Ah.
in 2002 or higher secondary in 2018.
mm.
That is your lordship will kindly come to this 42. This is the information we received under RTI.
Age?
Page 42.
Ah,
I certified that she is so and so, so and so, so and so. Probation examination 2002. So that is her HSLC. She is joined in the service in 1990. And next page, page 14. Next page 14.
14, annexure 14.
Next, 14,
Ah,
page 43. Higher secondary level examination 2018. This is in respect to Corona Handa, the private respondent. In fact, she passed her higher secondary in 2018.
mm,
But it is recorded in that particular document, prepared under the authority, disclosing the fact that she passed her higher secondary in 2002. So that fact has been suppressed before the authority, and accordingly, her service got promised. In fact, this is admitted by the director in their affidavit. So, lordship, kindly have this affidavit filed by the director, This is admitted,
she has not entered appearance.
Yes.
Has she been served?
He saw, she is, used not to appear in this case, and in fact, there are several others to the effect, according to her absence.
Hmm?
By last order, this court has,
Yes.
intended to take, proceed with the case, then some difficulties was there, on the part of the department. And accordingly, on that day, adjournment was there. In fact, court proceeded, to hear the matter, despite she was served, 2 times, First, she appeared, then, again, court, found it appropriate to, issue notice once again, since he is not appearing, despite she had entered appearance in this case. So second time also, she received notice,
She was soon appointed in
1990. The lordship will have it, page 40 of this affidavit of the director. Page 40 starts, there are 4, That the deponent denies the correctness of the statement, the lordship has got it,
Mm,
of the statements made in so and so, of the repetition which are not borne out from records of the instance. It is mentioned herein by the answering respondent that the minimum requisite qualification of assistant teacher of every school before so and so was HSLC pass. Thereafter, the Assam Elementary Education Provisional School, which 1977 was amended by the Assam Gazette notification number so and so, dated so and so, whereby the minimum qualification for the post of assistant teacher in lower primary and upper primary schools was prescribed as higher secondary or any other examination of equivalent standard having 45% marks in any of the qualifying examinations, higher secondary or SSLC for general category and minimum 40% marks for reserve category. Now, the respondent number 5 was appointed by the school management committee during the year 1990. And at that point of time, HSLC was the requisite qualification for assistant teacher of LP.
Okay,
Subsequently, he
we'll
took the
take this up. We'll take this up after some time at our scroll doc standing council education, school education. Court number 23 video kata. Yes, after some time.
Item 10.
Huh? Out of? Huh? Yes, Mr. Goswami, she wants a pass over for the day. What is the matter about?
Matter, Lordship, it is the gratuity and pensionary benefit, Lordship. Already, Lordship, the matter has already been settled, Lordship. In the IA Civil 3761/2025, Lordship, it is connected with this matter, Lordship. In that, Lordship, we have the authority and the petitioner, Lordship.
Ah.
We made an agreement, Lordship.
Hmm.
5,000 each in every month, Lordship. We are releasing, Lordship.
When will you be available? When your senior would be available? Please this matter again day after tomorrow.
The records. উকিলক খবৰে নিদিয়ে।
We'll take this up day after tomorrow.
Lordship.
Item 11.
Suddenly, the pay commission scale method, what happens here,
Ah.
some recovery issues.
Huh?
The petitioner was not, before he, he completed his PhD. Because he was using the scale with the principal of the college, and he was drawing the scale.
Hmm.
And the sixth pay commission also that was not continued.
Hmm.
Because he completed his PhD in 2012.
Hmm.
For the 19 his, that the condition was taken out, because that in the meantime he has instead of PhD. Now, and he was shown to be entitled to use the scale.
Hmm.
But since he was receiving the scale from the earlier period, there is an issue of royal around amount of 14 lakhs.
Hmm.
Not. Now, this is why the matter is pending. Because of this, those no order has been passed. The principal was asked to make some calculations and it comes to 14 lakhs 55,000 odd.
Hmm.
And that's why the fixation has been held up since 2016. That is the case. Basically, it's with the recovery now.
When did he do his, when did he got his PhD?
PhD he got it 12 mellow.
Hmm.
And notification was 2019 mellow that was made out, the condition of withdrawn mellow. Page 28. Next chapter. Inviting reference to recognition of this concern and directing the state to government of the higher education department to withdrawal of condition on the approval of appointment imposed by President so in respect of the Dipankar Das Chaudhary, assistant professor in department of mathematics, and allowed to draw into scale pay with allowances in from 23 to 112. As he has acquired PhD degree from Assam University, Silchar on 23 to 12.
So they've agreed to give you the UGC scale of pay from 2012.
12.
You want it to be from?
I know, I was drawing this scale earlier because of that's the problem.
Oh.
That's why the excess payment was paid.
From 2000 to 2012.
2012.
Those 12 years you need to repay is according to them. Yes, why?
Without the approval of the government,
Ah.
the principal has fixed.
Huh?
It was a
So recovery from the principal.
It's a conditional appointment.
No,
we
no,
have-
recover it from the
we have-
principal.
We have issued so cause notice to the principal also.
Huh? You recover it from him. Did he ask for the pay? No.
No, it was to the knowledge of the petitioner, Lordship.
Could be.
Everything was knowledge of.
Was it not to your knowledge what pay he was drawing?
No, Lordship, the principal fixes
Tell
it
us.
and just send it to the
To the whom?
treasury officer, etc. Lordship.
Huh? So the
there are-
principal knows it.
It was paid to him. Lordship.
Recover it from the principal, sir.
Then
Why from the person who's
I'll come
got-
with some judgments. I have
saying what?
regarding the conditional appointments, etc. In our court's judgments,
Oh.
are also many
Oh.
judgments are there. So it was to the knowledge. I have categorically stated in my affidavit also.
Ah.
Lordship. In that affidavit, the Lordship may please come to Lordship may page 19.
He does not make his pay slip, does he?
No, Lordship.
Does he make his
No,
pay slip?
no.
No, who makes his pay slip?
The principal Lordship for
Recover it from him.
Page number 19 is
Ah.
the appointment letter, conditional appointment. Once he
Page number?
clarifies- Page number 19.
Okay.
Then it is a conditional appointment that once he clarifies net slate PhD, then
Ah.
he will be entitled.
Yes.
He was well aware about that. Then principal fixed it.
No. Where is the copy of the payslip you had given to him?
Copy of the basic. No,
Did you give him a copy of the payslip? This is what we are paying you. No.
no.
You put the money in his bank.
Yes, Lord.
He happily took money, whatever is there in the bank.
Yes, he was taking happy.
He's
But
happy.
he obtained the eligibility criteria in 2012.
Huh.
We have given him from that. There is no dispute, Lordship. We have given him from that.
Ah.
He was entitled from that period only. And he was well aware, condition was imposed on him that principal he has no authority, Lordship. We have, Lordship may come to page 30.
Page?
Page 30. Again. P0, annex 13.
Just a minute. This letter is addressed to whom?
Page 30, two principal.
Page 19?
Lordship.
Page 19 is
Page-
given to whom?
Page 19 is. College. It is to the college, Lordship, because the letter, the.
It is only to the college.
College.
He did not get a copy of this.
The principal, secretary.
No, did he get a copy of this?
Yes, Lordship.
No. He is requested to submit necessary proposal for formal approval of appointment,
Yes.
enclosing the copies of joining report, appointment letter, and copy of prior approval of
Yes.
appointment and salary.
Page 23.
Salary of the incumbent should not be disbursed till the formal approval of appointment is accorded by the DHC.
Lordship. Page
Now-
20, Page 20.
Just a minute.
20.
That is page 20 I have read.
Lordship.
Page 20 I have read just now, the last line.
Lordship. Lordship.
So there was a formal proposal and a formal approval.
Yes, approval.
Now the letter on page
Approval
22.
was- Approval was under condition, with condition.
And thereafter salary would only start after you approve it.
Yes, yes. That condition was 8,000. He will receive 8,000.
Salary, whatever is to be dispersed after your approval,
Yes, Lordship. Yes. Yes.
correct? Now page 22.
Page 22, Lordship.
What does it say?
It says that the in pursuance of so-and-so, dated so-and-so, BHC so-and-so, Shri Dipankar Das Chaudhary of Vidyarthi Bhavan so-and-so, land number so-and-so, is hereby appointed a lecturer in the Department of Mathematics of this college in the scale of pay of 8,000 so-and-so. This is the principal.
What is so and so?
8,000 to
Mm.
13,500,
Mm.
13,500.
Mm.
With other allowances as admissible under the rules,
Mm.
he will be treated as probationers and liable to be discharged if he fails. to
Then
obtain the-
copy is given to?
Copy is given to the director,
Ah,
head of the department, Lordship. Yes.
now. Then
But-
pursuant to this, pursuant to this
he joined-
letter,
He joined,
he joined.
he joined.
He joined in the scale of 8,000 to 13,500.
Lordship, 1,000,
Yes.
2,000. Yes, on the same date, Lordship.
Yes.
Yes.
Then this letter was also given to the Director of Higher Education.
Yes.
Unless the director approves, the treasury will not pay any salary to any man.
Lordship.
Yes.
No,
So the
Lordship,
director
after-
approved or did not?
No, this one, after joining, this is not sent to the director.
Hmm.
Direct, it is sent to the treasury only along with his appointment letter and joining.
No, it is not.
Yes,
No,
this is a
it is,
joining letter.
it is not marked to the treasury. 22 is not marked to the
Not-
treasury.
It is marked to the only principal only.
Ha. Then,
Then Lordship, that page 24, next, he obtained the
Page?
PhD.
yes.
Yes, he is qualified now.
Ha.
So once he qualified, he obtained it on, once he qualified in 23 February 2012. Below, Lordship, register sign. Right below, 23/12/2000. Then Lordship may come to page 28. Now, Lordship may come to page 28. This letter was issued on 2019. He completed PhD in 2012. We have given him the retrospective benefit from
Ah.
that date. Page 28.
Hmm.
It is, we issued it on 2019 and giving him
Where is the reply of the
principal.
principal?
That is, Lordship, I have to obtain instruction. What reply? At
Where is
page-
that reply?
Page 30. Page 30 is our show cause notice to the principal.
Then what happened?
Then Lordship, that is,
Thereafter, what happened?
Lordship, thereafter directly Lordship, the principal.
Mr. Dotto?
Principal may have sent a statement with regard.
No. You knew that you were supposed to draw at the minimum scale.
I was given that scale by the principal.
Could be, but you knew that your appointment is on the minimum until you clear the net slate.
There,
Hmm.
it's in the granting a 6-pay commission also, the bank, they did not raise any point of dispute at that point of time. But when will 7-pay commission payments, benefits should have given question.
No, they cannot withdraw if it has been given for a certain period. It was already given to you for 5 years and more. Then how can you do it?
Lordship, I'll come.
Then how can you do it?
On Thursday, day after tomorrow, maybe matter will be fixed. I'll come with the principal's reply also regarding that also.
Day after tomorrow, Thursday?
Query also.
Release this matter again on 12th of March for further hearing.
Obliged.
Can it be without 17th or 13th?
On 13th, Friday.
Can-
On Friday. Friday.
I'm being at the matter is,
Obliged.
otherwise,
Yes, sir.
Lordship, in this matter, we have filed our affidavit, my lord.
When?
We have filed it on Lord, February 26th, my lord. February itself, my lord, on that day. My lord. And after filing, my lord, I have brought on record, my lord, the instruction with which the Honorable Court had asked us to bring. That is, my lord, regarding, my lord, as to whether, my lord, the petitioner is eligible for promotion, my lord. Because what has happened, my lord, by the way of this affidavit, my lord, we have brought in, my lord, that the petitioner has been appointed. If your lordship comes to the writ petition first, my lord. Lordship will come to the writ petition first in Annexure 1, which is, my lord, dated 23rd February 89. That is his appointment, my lord. Appointment has been given by the Government of Assam Irrigation Department, my lord. So via the SAD, he is claiming promotion from us, my lord. But actually the Irrigation Department has given promotion to the petitioner. Now, lordship will come to, appointment.
Who has given this?
He is giving, not me. And my lord, kindly come to the affidavit which I filed at page 33 first. 33 of my affidavit, additional affidavit which I filed. Page 33. Annexure A1. With reference to subject cited, I'm directed to say that Assam so-and-so amended, and my lord, as per the said amendment, secretariat means all the departments of the government secretariat, the staff of which are appointed by the general administration, secretariat establishment and general administration department only, against the permanent post of the concerned department. The petitioner Upen Das was appointed by the irrigation department. As such, his matter is not covered by the existing service rules. Now, lordship will come directly to page 35. Lordship will come directly to page 35, which is the rule, my lord. The exercise of powers conferred by the Article 309, my lord. Assam Secretariat, Grade 4 and Record Supply Service Rules. My lord will come directly to subclause 1, appointing authority. Appointing authority means the deputy secretary to the government of Assam in the Secretariat Administration Department, and in the case there is no deputy secretary in the Secretariat Administration Department, under secretary of the Secretariat Administration Department. Now again, my lordship will come to the appointment letter which which the petitioner has annexed. Petitioner has annexed at page 15, annexure 1. That is, my lord, irrigation department, my lord. And he has been appointed by an undersecretary of the government of Assam irrigation department. So what we are trying to say, my lord, is that he falls under the irrigation department, and if any promotion is to be given,
In the
it will be- it
absence
has
of a
to be
deputy secretary, it will be done by an undersecretary.
undersecretary. But
Is there a stand in your affidavit
my lord,
that there was no there was a deputy secretary available at that point of time?
no, that is not our issue, my lord. My concern is that the appointment was given by irrigation department. So the irrigation department will be the concerned authority who will give in the
Assam
promotion.
Secretariat Grade 4 record
Yes, ma'am.
suppliers, that page 35 you were reading.
My lord,
For the Assam Secretariat,
my lord,
for the Secretariat service, if there is a deputy secretary,
my lord.
he will be the appointing authority. If there
Correct.
is no deputy secretary, who will be the authority?
Undersecretary.
Who has issued the letter to him? Undersecretary.
Undersecretary in the irrigation, not the SAD, not Secretary Administration, not my department.
Where is that appointment letter again?
Appointment letter is at page 15 of the petition, annexure 1. Page 15. It is the undersecretary, my lord, undisputed, my lord,
Okay.
but it is the irrigation department.
Okay. I'll just be back in 2
Right.
minutes, sir.
Irrigation.
What was your case? Tell us again. We are ready for a disposal, Mr.
Yes, Milord. Yes, yes, Milord.
Lordship, my instruction here is, Lordship, though we have appointed him in the grade 4 department, that is
We are ready for a disposal.
probably, Lordship,
What?
I need some more instruction. Lordship.
What instruction?
Instruction in the regard, Lordship, there is no grade 3 post in our department.
Ah,
So we, on our own, Lordship, we cannot promote him to grade 3 post because there is no post. In the secretariat, in the irrigation department, there is no grade 3 post to promote him, Lordship. So,
secretariat.
in the secretariat, Lordship.
No,
Within-
he's saying that he is not even appointed in the secretariat.
He is appointed in the secretariat, Lordship.
Appointed under the irrigation department. So we kindly see annex 1, page 15. He's appointed by the irrigation department. So had he been appointed by a deputy secretary or a under secretary from the SAD department, then this rule would have applied to him and he would have got a promotion. But here in this case, my lord, apparently he is a person who has been appointed by the irrigation department. So our department has said that it is the irrigation department is the department which will give him promotion. But here the irrigation department has come up, my lord, with previously that they don't have any promotional avenue to the next higher post from them. So that is the question now, moot question. And my lord, he has to take instruction as to whether if there is a rule or something which they are relying on.
What is this judgment you are relying upon? Hmm. He has rendered your service, his services where?
In the irrigation department, in the secretariat, Lordship.
This is issued by the undersecretary cost control.
Just a minute. He has Secretariat Administration Department. In this case, it was on, he had rendered service in the Secretariat Administration Department.
Irrigation. Petitioner irrigation.
Ah, because he rendered service in the Administration Department, this order was passed. Yet, read the next line. Continue reading the line. Now, did you render your services? Yeah.
Water resource department, public health department, all are under this, in this subordinate secretary service in 1963 our district. Paragraph 20 will be represented. It's the observation of the survival of both services.
Have you seen this judgment?
Lordship, I have seen this judgment, but this judgment applies to that person who's worked in the SAD directly, man, and appointing also.
Have you seen paragraph 22? What we have said is what you have simply repeated to us. Have you seen para 22? When? Tell us on 13th or 12th. Go to the judgment.
I'll go through, man.
List this matter again on the 13th. Sorry, 12th. 12th of March. For further consideration. I think that judgment will cover it.
I have, man, I'll also bring in if I required one. Another judgment.
Party.
Obliged.
Item 12.
Hmm? A request has been made for adjournment of the matter by the, on behalf of the learned counsel for the petitioner, list this matter again on the 22nd of April.
Deeply obliged, Lordship.
Kuntal? 13 to 12, right? What of it? Yes?
Before my learned friend starts, my lord,
Huh?
I am appearing for the Tezpur Law College, my lord. How
Yes.
this writ petition is maintainable, my lord? Series of judgments. Let my learned friend first satisfy how a writ is maintainable, my lord. Because it's a contract of personal service. It cannot be enforced in a writ court. Ma'am, there is a latest judgment, 2023 4 SCC 498. Is this one? Saint Mary's. Saint Mary Education Society. No, like, it's not a question of after or before. Question is, what is the proposition of law? Yes, yes.
This has been also discussed this. There is only one point that can be distinguished.
When a matter can be disposed of early, why should you spend court's honorable time,
No,
valuable
no.
time?
But I also have to discharge my duties towards my client.
Yes.
It's not that.
Lordship will kindly have a look at 75.2 and 75.3. Asile. Please come to page number 537, my lord.
What is the fact actually?
No, my lord, it's a similar, absolutely similar facts.
Okay.
Yes, it's a Saint Mary's Education Society.
Hmm.
Please come to para 75.2. These are the conclusions which was drawn by the Honorable Supreme Court. Para 75, I'll have your lordship's kind attention to 75.2 and 75.3. Even if it be assumed that an educational institution is imparting public duty, the act complained of must have a direct nexus with the discharge of public duty. It is indisputably a public law action which confers a right upon the aggrieved to invoke the extraordinary jurisdiction under Article 226 for a prerogative writ. Individual wrong or breach of mutual contract without having any public element as its integral part cannot be rectified through a writ petition under Article 226. Wherever courts have intervened in their exercise of jurisdiction under Article 226, kindly see, either the service conditions were regulated by statutory provisions or employer had the status of state within the expansive definition of Article 12, or if it was found that action complained of has a public law element. So end of the day, my lord, supposing, my lord, even if a particular, say, my lord, particular person is owner of a shop, he is employing a, my lord, employee. If he violates the Provident Fund Act and rules, then, my lord, it will lie. Now, here it's a case, it's a contract of personal service. How can it be enforced? Then please come to 75.3. It must be consequently be held that while a body may be discharging a public function or performing a public duty, and thus its action become amenable to judicial review by constitutional court, its employee would not have the right to invoke the power of High Court conferred by Article 226 in respect of matter relating to service where they are not governed or controlled by any statutory provision. If my learned friend can show that the service condition is governed by a statutory condition, it is otherwise, it's a contract, my lord. Then, my lord, one more small judgment, my lord, which has been referred to in this very judgment. If your lordship would kindly come to page number 522.
5?
22. It's a part of para 37, my lord, where KK Saxena's case was quoted. Please come to that quoted person 52. It is tried that contract of personal service cannot be enforced. There are three exceptions to these rules, namely, when employee is a public servant working under the union or a state, when such an employee is employed by a body or authority which is state within the meaning of Article 12 of the Constitution, when such an employee is a workman within the meaning of Section 2S of the Industrial Disputes Act and raise a dispute regarding his termination by invoking the machinery under the said act. So, my lord, the three exceptions to the rule of that a contract of personal service cannot be enforced are the three. So, he does not fall in it. So, therefore, my humble submission is, my lord, by whatever yardstick, my lord, we view at this issue, my lord, Tezpur Law College, by any stretch of legal reckoning, it cannot be construed that it is an authority under Article 12 to be amenable to the jurisdiction of this honorable court, my lord. Unless my learned friend can satisfy your lordships.
But may I submit?
Mm-hmm.
I have also cited these judgments and even one latest judgment from the Honorable Supreme Court rendered on May 21, 2025. But the distinguishable part in this particular case is that the Tezpur Law College receives government aid. I have filed an additional affidavit showing that the Tezpur Law College receives government of rupees 3,75,57,000 in the year 2012-13. And thereafter also, if they received, I do not know. I have collected one document and filed an additional. If they received government aid, then the expanded meaning of Article 12 is plus the government act, the non-government traditional, the name of the new name of the act is Assam Non-Governmental College Management Rules. Their governing bodies have to get the approval of the directorate. Therefore, my respectful submission is the government has deep and pervasive control over the law colleges. Lordship is ever lordship this under JB law college. So management of the college is under the deep and pervasive control of the government. They receive government aids. Now, you cannot henceforth now citing this judgment from the Honorable Supreme Court saying that it is not amenable. Yes, it is true that to some extent this is the private law. This is but the management of the menacing control, even pervasive control of the government of the college is there. They receive financial aid. How they can overcome this one? And here is the point that can distinguish these judgments. So far as this college is concerned, my difficulty today is this law. I mentioned in the morning this judgment that your my senior friend had shown me. And one more judgment I must inform the other side also. That's 2025 SCC online SC 1192. This is a 3 judges judgment. It is discussed all the judgment. This judgment of Saint Mary's, Andi Muktaram Sadhguru, and this Janet Japal that day I showed to your lordship. Janet Japal is also discussed here. But I got this judgment in the morning. My predicament is this today that I have to go through the whole judgment. There are some paragraphs are here which goes against me, of course. But this point that they receive government aid and they are within deep and pervasive control of the government. These 2 points they have to overcome. And in the meantime, lordship will grant me some time to go through judgment and apply them. On Monday, Monday 16th, just 5 years later, for this, Monday 16th of March, the lordship will. Because I am not wasting time of this court. I cannot understand the impact of a Supreme Court judgment. Judgment also there are some paragraphs which goes against me, but it does not discuss this point that when a college receives government aids, and they are deep and pervasive control over by the government, and so far as the constitution of the managing committee, then what will happen? This is not discussed in this judgment. That is why let us have some time. Let me examine. I'll come back with proper arguments and distinguishing with distinguishing factors, if possible. Otherwise, you'll come straight and say, this is not my case. But let me have some time.
Look, I have no objection to my learned friend making submission on 16th. Losses, kindly give me 2 minutes time with that.
Yeah.
Now let us place the law in this regard in perspective. My lord, Andi Mukta, that 1989, what was that case? Question is, when you discharge a statutory obligation, then even if the body is private body, then a writ would lie.
What he's trying to say is that
No, I'm coming
the
to
government
the
has some
permissive. No, my lord, I'm
control.
coming to it. That aspect has been taken note of. My lord, Imperial Bank has not been held to be a state. Indian Council for Agricultural Research has been held not to be a state. Why? My lord, Lordship will kindly appreciate if we try to trace the law in this regard. My lord, International Airport Authorities case, this point arose. Then, my lord, the Justice Bhagavati said that Article 12 has to be given a very expansive meaning in certain respect because the governmental activities have increased manifold. The normal bureaucracy consisting of the Indian Administrative Service and the state civil services, they are not enough to, my lord, cater to the requirement. That is why, my lord, this concept of state enterprises came up. Therefore, my lord, whether this entity is created by statute or it is created under the Societies Registration Act is not immaterial. What is material? What is the functions they discharge? Therefore, my lord, it was said these are all extended arm of the government.
This Saint Mary's case,
Yes.
it opens with the words
Yes.
private unaided minority educational institution.
Yes.
Now here private to some extent, yes. But the unaided part is where he's trying to
No, my lord.
distinguish it.
My lord, Supreme Court had said that if an entity is receiving some aid from the government, then it is one of the indicia that it may have some control.
Yes.
The only one.
Only.
But we are not on that. We are not on the constitution of the body. We are on, my lord, what he wants to enforce. He was appointed under a contract.
That aid which has come
Yes.
is also related to functioning of
No,
the
but that's,
institution.
now, if your lordship should kindly come to this paragraph 75.2, please see, come to that, my lord, opening line. Because imparting of education is a public duty.
No, that is one
Please
part.
see,
We are
Milord.
not on that.
Now let us come to 75.1. An application under Article 226 of the Constitution is maintainable against a person or a body discharging public duties or functions. The public duty cast may be either statutory or otherwise, and where it is otherwise, body or person must be shown to owe a duty or obligation to the public involving public law element. Where does my learned friend satisfy this line? That is where 1989 Supreme Court comes into play. That's why I said, my lord, if he says that there is a statutory obligation, if there is a violation of a statute while terminating his services, then, my lord, he has a case. So this has to be seen, my lord. That's why I said the example of a provident fund. If, my lord, a private employer does, what was the 89 case, my lord? Some provident fund benefits were not given. So that was a duty cast by statute. But kindly see this line. The public duty cast may be either statutory or otherwise, or where it is otherwise, the body or person must be shown to owe that duty or obligation to the public involving a public law element. If under a statute, there is a certain requirement to be complied with before terminating the service of a private employer under a contract, then yes, not otherwise. But otherwise, my lord, that will make it very expensive. Merely because some grant is, that's only once it was received, my lord. For the subsequent years, we have not received. So, end of the day, my lord, the test is the violation complained of
Hmm.
must emanate from some statute. That is my humble submission.
Without, if lordship comes to this binding volume of regulation 490922, page
Very correct.
26.
So, my lord, Supreme Court has said
Hmm.
whether the entity is created by statute, whether it is created by Societies Registration Act, that is immaterial.
Hmm.
What is material is what is the nature of the function that is there discharging, and what is the allegation of violation. If the violation of a statute, then if that employer has a duty to discharge that function within the meaning of that statute, then
Then
yes.
it is.
That's my humble sum.
Page 26 of that binding.
Next time on 89 was husband one.
Page
26.
26.
This is the advertisement. This is how I was appointed.
Hmm.
Testful law follows, testful Supreme as an advertisement of principal. Applications are invited from engaging benefits for the testful principal whole time. For testful law follows, applicants could register qualification experience as per norms of Bar Council of India, the PTC may apply within 10 days. Therefore, the application, the appointment is of the candidates, it's not XYZ. They have followed the particular norms and the regulations of the statutory bodies. The college is managed by a body which has to be approved by the government.
No, no.
Yes.
No, no.
Huh?
Experimental.
I was on 16th, I will show the laws, I have annexed the laws also in this.
Not 16, we can have it on the 17th.
Yes, yes.
The 17th is
Yes,
No problem.
on 17th.
My lord, I'll bring that 89 judgment, which is the deciding part.
We'll just have to see whether the, what he has said, the aid which is received.
Aid we received only for one particular year.
Ah.
That we have seen.
That will not alter the situation.
Hmm?
They receive once or.
No, no, that's not the only criteria, my lord. That's not the only criteria. It's one of the indicia.
We'll have to draw the criteria. We'll have to see whether your discharge from service, that is what you are challenging, a discharge from service. Whether your discharge from service was done
In violation of any statutory provision.
or whether it was a public duty being discharged, which required to follow, which we can interfere with.
Fact that they receive from, and they have, the government has the deep and pervasive control.
And
Our
deep and
right
pervasive
to-
control is what. We'll see that. At the request of the learned counsel for the petitioner, list this matter again on the 17th
Well.
of March. Okay. This week we are not sure what we are keeping part heard.
In any case, matter will come up on 7th.
It will come up.
Have a blessed.
Yes. Yes. In the morning, there seems to be a scarcity of education councils. Is
No,
it so?
Lordship, I was actually on Lex.
No, scarcity of councils. You are not the only one with the saddle with the burden.
Apologies, man.
Huh?
We'll apologize. We'll make
The
sure
next time we are going by non-appears. Yes. The
Case 41
hmm.
of the affidavit filed by the director. Yes, madam, affidavit dispatch, madam, that at the time of joining, madam.
Are you aware of the facts, Mr. Fukun? What has
Lordship, I've
happened
gone
here?
through the thing, my lord, that
Ah.
I've gone through the affidavit, my lord.
Hmm.
And my lord, if your lordship sees the date of joining, my lord, of the petitioner and that of the respondent number, if your lordship comes through,
Documents show the respondent has joined earlier.
my lord,
No difficulty.
my lord. Annexure.
What is the grievance in the writ petition?
Annexure, this thing, my lord, 24, page 24, my lord,
Come to your affidavit.
my lord. Page
Come to
30,
your affidavit, page 41.
my lord.
Do you have it? Page 41?
Yes, sir.
Top two lines. It is mentioned herein by the answering respondent that the minimum requisite qualification of the assistant teacher in LP school before 10/11/95 was
HSLC.
now. Kindly come to the annexure. Where was it?
24, man.
Yes,
Page 42. That is one of HSLC before the.
page 42
Page 42, annexure 30, sorry.
of the writ petition. Yes, come to page. এই ইয়ার একটা গন্ডগোল হয়ে আছে এখন ঠিক করছো এখনতে হয়ে আছে নে হ্যাঁ ইয়াতে দুইখন রিট পেটিশন কাটি থৈছে মই একেবাৰে দুখন কৰি আছো এখন গুচাই দিয়কচোন এইখিনি পৰা গুচাই দিয়ক এই পাৰ্টটো গুচাই দিয়ক এখন সেকেন্ড রিট পেটিশনখন ইয়াত গাঠি থৈছে মই বাৰে সেইখন লুটিয়াই থাকো দিয়কচোন amended writ petition. Why an amended writ petition?
I got the information under RTI.
Huh.
That kind of these two papers, kind of.
Okay. Then the amended writ petition itself. Page 42. Do you have it? Do you have the amended writ petition, sir?
Yes, not sure. I'm going through it.
Page 42. Examination in 2002.
2002.
So when she was appointed, when she's shown appointed in the year 1990,
And how come she's got this one? 2002, man.
she did not have the
Qualification.
now. Come to the proposal sent by the school authorities.
At page, my lord,
24.
24, man. It has shown as my lord, 2002.
Aruna Haldar, 1/1/1972.
I know.
The caste is 2, category is 3, year of joining 1990.
1990.
Thereafter, highest qualification academic, you see 2. Now come to the below the end of the page.
My lord.
Below secondary is 1, secondary is 2. Do you find? Below the signature, that long line,
My lord.
others is 7. So she was appointed in 1990. She got her class 10 in?
2002. Oh, my lord.
Could it be done? Could she have been appointed?
No, man. Some anomalies then.
Then?
Plus, she's not.
Huh?
Plus, she's not here also, no, my lord. I mean, she's not appearing also.
So,
As private respondent, she's not appearing also. I think entered appearance also.
did you have a interim order? No interim order.
The council appearing for this respondent number 5.
Ah,
The file house then never came. That's why this court directed me to take press stage for the top of the respondent number 5.
Hmm.
For the second time. I took steps, there was report that she has received this notice. Even then nobody is come. On behalf of.
and this RTI that reply to the RTI in the affidavit, where is it? Your RTI reply?
Here reply, these two documents were supplied by her.
By herself.
By the respondent number 5. So she
Where is
was
that?
verified.
Page 41, if I'm not wrong. Please have page 41.
It is by herself. It is certificate, enclosed and age, SSL. These are the documents by herself.
I'll leave it to your lordship.
Heard, Mr. Learned counsel for the petitioner also heard Mr. A. Pukul, learned counsel appearing for the Department of School Education.
1, 2, 3, and 4, man.
Who appears for the DLS, the district level committee? It is by the deputy commissioner.
Man. They, I don't think it's a party, man. 1 to 4 is the elementary education, and fifth,
The-
number 5 is 5. Private is 1.
Grievance raised in this repetition is regarding the provincialization order number. You will find it at page 16. Ma underline kori thaisu, hobo? Issued by the Director Elementary Education Assam Kahelipara Guwahati 19, whereby the services of the respondent number 5 in this writ petition had been provincialized. The orders of this court reflect that despite receipt of notice, the respondent number 5 had failed to appear and contest. The writ petition alleges that the respondent number 5, who was shown on records to have joined the Bal Vikas Shiksha Sadan within bracket LP school, what is that school? Huh? You are showing the document of some school and then
The Southern LP, page 39.
Bal Vikas Shiksha Sadan LP school. Huh?
Then,
Then, yeah.
page 39.
Bal Vikas Sadan LP school in the year 1990. Now, what did I say the sentence? Kindly start the sentence again. The repetition alleges that 5 in the year 1990, had obtained her high school leaving certificate qualification in the year 2002, and therefore it is the submission of the learned counsel for the petitioner that as in the year 1990, the respondent number 5 did not have the qualification to have been appointed as a teacher, assistant teacher in an LP school. Full stop. It is relevant to note here that upon provincialization of the services of the Bal Vikas Sadan LP school, the school was amalgamated into the base school, into the Balmiki LP school, which was taken as the base school. The learned counsel for the petitioner has drawn attention of this court to the reply furnished by the respondent number 5 to the Public Information Officer, Office of the Deputy Inspector of Schools, Nagaon, Assam, wherein the respondent number 5 had herself given the HSLC examination certificate issued by the Assam Sanskrit Board, Gauhati, which reflected that the respondent number 5 had passed the Praveshika examination held in the year 2002 and was placed in the 3rd division. the respondent number 5 had passed the higher secondary level examination in the year 2018 under the Assam State Open School under the Assam Higher Secondary Education Council. The Learned Counsel for the petitioner has submitted that since the petitioner was not qualified to hold the post of a teacher in the year 1990, respondent number 5, respondent number 5 respondent number 5 was not qualified to hold the post of an assistant teacher in the year 1990 in an LP school, her recommendation for provincialization of services was an apparent error, and the same requires an interference of this court. Full stop. The Learned Counsel for the petitioner has submitted that in the absence of the respondent number 5, it is the petitioner who should have been recommended for consideration for provincialization, and the mistake initially occurred at the level of the school when the names were being recommended, and further again when the district scrutiny committee, as required under the law, did not make proper verifications. It is the further submission of the Learned Counsel for the petitioner that the error continued when the state level scrutiny committee, or the state level committee, what is it called? State level scrutiny committee and the government, while finalizing the matter, also did not verify the antecedents of the persons whose names were being forwarded. Full stop. Accordingly, the Learned Counsel for the petitioner has prayed that the order dated 5th of February 2021, insofar as it relates to the provincialization of the services of the respondent number 5, namely Aruna Haldar, as a tutor in the Balmiki LP school, which was the base school, requires an interference, and further orders are required to be passed directing the respondent authorities to consider the case of the petitioner for provincialization under the same terms and conditions on which the services of other teachers of venture LP schools had been taken up by the respondent authorities. Mr. Fukon, Learned Counsel, appearing for the Department of School Education, has referred to the affidavit in opposition filed by the director, wherein the process for scrutinization had been elaborated, and a stand has been taken that the district scrutiny committee had recommended the services of 2 other teachers without recommending the name of either the petitioner or the respondent number 5 at the first go. Full stop. However, by a letter submitted by a letter dated 19/12/2019, submitted by the district elementary education officer, certain corrections were made in the recommendation to the extent that the name of the respondent number 5 had been included in the recommendation. Full stop. Thereafter, as per the affidavit of the respondent number, who is the director is respondent number?
Two.
Respondent number 2, 2 persons, namely one Joylal Prasad Mahato and the respondent number 5 were recommended for provincialization. The stand taken by the director in the affidavit is that the name of the petitioner was not recommended by the District Scrutiny Committee Nagaon for provincialization as an assistant teacher, and therefore the services could not be provincialized. Full stop. As regards the qualification required to be appointed as an assistant teacher of an LP school before 10/11/1995, the director has taken a stand that the minimum requisite qualification for the post was HSLC passed. It was in the year just a minute, Mr. Fukon. Mr. Fukon, page 41.
My lord.
10/11/95 or 10/11/2005?
2005, my lord. My lord,
Then why was it, and why on the top it is written 10/11/95 it was HSLC?
my lord,
There are some substitution time to time.
Show us where.
When you come to matter, at that point of time, this elementary rules 1977 was prevailing.
Where is that?
Petition manual, madam.
Ah,
That is relevant rules kind of
293.
293. Kind of page 296. Qualification prescribed for the kind of elementary education teachers of the LP and upper LP and lower LP.
Then this, it will not be 1995, it will be 2005.
2005.
উপর যে 10/11/1995 লিখিলো 1995 লিখিছে তো within bracket লিখি দিয়ক 2005 SIC, huh? Full stop.
Typographical error.
The respondent number 2 in the affidavit has taken a further stand that after the notification of 10/11/2025, the minimum qualification for appointment as an assistant teacher had been kept at higher secondary or any other examination of equivalent standard having 45% marks in any one of the qualifying examination, either higher secondary or HSLC, for general categories and minimum 40% mark for the reserve category candidates. Full stop. The specific stand of the director is that at the time when the respondent number 5 was shown to be appointed to the school, the requisite qualification for assistant teacher of LP school was HSLC, full stop, without referring to the qualification of the again take a look, page 41, last line of the paragraph number 4. Subsequently, she passed the higher secondary school leaving certificate. Is it in 2002? What does the record say? What does the RTI say? Will impose very heavy cost. Filing affidavits without going through the conference. She passed the HSLC higher secondary level examination in the year 2018. Page 43.
Typographical error, man.
Which one is? 2002 is a typographical error or HSSLC? Subsequently. When they say subsequently, HSSLC is correct. So the year is wrong. Trying to mislead.
Claimed by the respondent number 5 that she passed 2000.
Where?
That is their document.
They had a copy of the writ petition.
In fact, that is what I just referred to this page. I think page 25.
हाँ, ठीक है. Done?
Page 25.
ये लिख लीजिए. Subsequently.
Page 25.
हाँ, ठीक है. Last line to কি লিখেছিল? हाँ, हाँ, हाँ. Requisite qualification for assistant teacher of LP school was HSLC. Full stop. The affidavit further states that the respondent number 5 passed the HSSLC examination during the year 2002. Mr. Fukon, in this regard, has referred to the list of untrained in-service teachers in unaided recognized schools given at page 28 of the amended writ petition, which is a tabulation made by the headmaster oblique principal of the school, wherein it has been shown that the respondent number 5 has passed the HSSLC examination in the year 2002. Full stop. Next para. This court has heard the learned counsel appearing for the parties and has also perused the materials available on record. The records reveal that the respondent number 5 had procured the class 10 or HSLC certificate in the year 2002, and therefore at the time of her appointment in the year 1990, she did not have the qualification required to be appointed as an assistant teacher of an LP school. Full stop. The court has also noticed the other manipulations, such as the tabulation forwarded by the headmaster oblique principal of the school, where the respondent number 5 has been shown to have passed the HSSLC examination in the year 2002. Full stop. What was this? The DIAS data for the year, DIAS data submitted on 30 September 2009 under the signatures of the headmaster and secretary shows the respondent number 5 to have the highest qualification of HSLC. Full stop. The documents submitted by the respondent number 5, which are attached to the reply to the RTI application, itself display that the respondent number 5 had obtained her HSSLC qualification in the year 2018. Full stop. Thus, it appears to this court that the entire provincialization, entire exercise for consideration of the services of the respondent number 5 for provincialization has been done on the basis of fraudulent and wrong information being supplied by the school authorities to the district level. What do they call it? District
Level scrutiny committee.
District level scrutiny committee. And the said information had been passed on to the state level scrutiny committee by the district level scrutiny committee without proper verification of records, full stop. The state level scrutiny committee had also failed in its duty in forwarding the recommendation to the government for approval without proper inquiry being made into the information supplied by the school level authorities, full stop. It is settled law that when that fraud vitiates the entire proceedings, and in the present case, when the very recommendation from the school was based on fraud, the final orders of provincialization cannot stand the scrutiny of law, full stop. In such circumstances, the provincialization order dated is, what is that order dated? 5th of February 2021,
In respect of.
issued by the director, is interfered with by this court and is accordingly set aside and quashed. Full stop. As a consequential relief, the respondent number 2, namely the director of elementary education, shall initiate appropriate steps from the school level itself to have the records of the school verified and to take up the case of the petitioner for consideration for provincialization of her services in accordance with law, full stop. The director shall also take appropriate steps to cause an inquiry as to how and under what circumstances the fraudulent information had been supplied by the school authorities to the district level authorities by furnishing fraudulent and unverified information while taking up the process of provincialization of the respondent number 5, full stop. It is clarified that since the provincialization of the services of the petitioner of the respondent number 5 was based on fraudulent and false information, the provincialization of the services of the respondent number 5 shall stand voided ab initio, and in case the petitioner is found entitled to have is entitled to be provincialized in accordance with law, the respondent number 2 shall also take up also pass necessary orders with regard to the you cut out that portion. A last was in case petitioner is found entitled to stop. The case of the petitioner for provincialization shall be taken up within a period of 45 days from the date of receipt of the certified copy of this order, and the process shall be completed within a period of 90 days thereafter. 90 days thereafter, the director shall cause all necessary inquiries as may be required in law to verify the credentials of the petitioner while considering the case of the while considering her case for provincialization of services. Read petition disposed of.
Yeah.
Huh?
Taken up at 2 o'clock, Miss RDB.
At
2 o'clock.
Lordship, here, As per the direction of your lordship, there was some clarification required from the finance. Lordship, I have received the, if lordship, it's a very small clarification, if lordship will like to peruse it, lordship, because.
Maybe
every-
you'd like to, maybe we would like to be first apprised of the facts of the case.
Yes, lordship, that.
It is the Guwahati High Court,
Lordship,
but there are several mini computers.
Lordship.
So data is somewhere else.
Yes, lordship.
Data has to come here also. Yes.
Sir, pertains to non-payment of provisional family pension
Ah.
and provisional gratuity. In person to the order, in person of the Malad kindly to page 23. There is the office memorandum 14 June 2016. 14 June 2016.
No, what happened? He was, deceased employee was drawing family pension under the NPS scheme.
PST.
Okay, then
But I have submitted Malad representation, but he said no step has been taken.
what representation did you submit?
40 Malad.
Page 40. Huh.
Join in service Malad area 2000 and separately in the 2013 Malad. This post was regular.
Huh.
And therefore he died on Malad 12 2017.
Okay. Then what happened?
In person Malad after office number he is entitled Malad provisional basis Malad family.
Huh.
Page 23 Malad. And Malad also Malad another office memorandum case 30 Malad section 9 18 June 2018. The procedure has been laid down Malad regarding provisional family pension.
Where? Page number
13,
30.
30.
What does it say? Ah.
Additional relief on death, disability of government shall provide under and new defined constitution NPR procedure to be adopted for submission of claims. Thereafter, Malad kindly see Malad page number 36 Malad.
Huh?
Another office memorandum Malad dated of February 2021. But TPG didn't also Malad office memorandum regarding Malad DCRG Malad. There some retirement cases.
Okay.
The NPS employee, but still that no step has been taken, Malad. They have submitted representation Malad page 40. Providing pension of service on the.
Yes.
Lordship, this representation has been filed since BTC. If lordship will peruse our instruction, lordship, small. I can
Is
file it
he
in the form of-
entitled to DCRG and family
Yes,
pension?
lordship, here, yes, he has, as per the letter that has been departed, given to us by the authorities in the BTC, he has been granted, lordship. So, lordship will just peruse our, that is there's a letter that has been annexed from the BTC authorities, lordship, since it's a transfer subject, they are the main authorities. But we have annexed one letter also from the BTC, lordship.
This family pension scheme that you had started,
Lordship, this.
is it over and above the regular pension? Or is it within the regular pension scheme?
Lordship, family pension will be.
I'm just asking.
Yes, it is, family pension is.
Compulsory family pension scheme.
Yes, lordship, that is during the lifetime, before the retirement period. That is compassion family. And the
now-
regular pension will be counted from the date of superannuation.
So he doesn't fall into that.
Yes,
He has died in harness.
Yes, lordship, in 2007. So certain relief, lordship, there's an OM, if lordship allows, I can put it in the form of affidavit because there are certain documents also.
This is a matter of when?
Lordship, 24, lordship.
24.
So, but mainly the decision
Just a
has to be
minute.
taken by the.
Also as per the civil petition. The civil pension extra independent. Yes, sir, it has been provided to you.
Certain
You will have to file an affidavit saying that it has not been provided to you. And if they can show that it has gone to your account, that DCRG part has gone to your account. And that EOP. No, EOP you have not given.
not all the relief, Your Lordship. Some.
EOP has not been given.
Some
Extraordinary
benefits-
pension,
Yes.
which benefits? Tell us.
I am not confirmed, my
Hey.
lord, that no document has been provided.
Sir, we sit down here to dispose matters with the hope that you are equipped with it. Is it not? We are being given admissions and hearings. If you now tell us that, we'll have to record it in the order then, if you are not prepared with the case. We'll record it, that since the petition, learned counsel for the petitioner does not have up-to-date instructions, even after orders had been passed by this court asking them to have updated instructions. Should we say that? No sum amount business. No sum amount. Then we'll close the writ petition saying some amount has been given. And so we do not know what is the grievance of the petitioner, huh?
Provisional family pension as provisional guest.
Yes, who pays the provisional
The
family
BTC,
pension?
Lordship, that has.
BTC who appears for it? You are paying for the BTC? Yes, madam, tell us. Have you given the extraordinary family pension? As per the office memorandum? You are awaiting instructions. Instructions will come tomorrow along with the officer concerned. Yes. Who is the officer concerned? Tell us. Why are they not responding to the court? Why are they not responding to the court? Sorry? From 2024, 25 gone, 26 gone. Family of your employees living without a pension. Who is the concerned officer? Principal secretary.
No, no,
We'll
no,
get the
secretary-
principal secretary here
secretary is a-
along with all the records tomorrow morning.
Lordship, the last instruction they had from the secretary, Lordship, if the secretary can clarify.
No, she's saying principal secretary. Tell us. Why the liaison officer?
Bodoland guest house.
He worked in the Bodoland guest house. Okay. Yes, tell us, secretary, BTC, personnel department or the finance department? Who comes?
The secretary
Tomorrow.
BTC, Lordship.
With all the instructions, huh? Secretary BTC, which one? 6 or 7? Why don't you have your instructions whether the pension is being paid or not?
7 to.
Yes, find out at 2. Whether the extraordinary pension has been granted or not. If not granted, why not granted? If we don't have an instruction at 2, the person comes here at 4.
Lordship,
How many hours from BTC to here?
4.
Tomorrow. We'll have him tomorrow if he cannot give you instructions today itself. It's pension, madam. It's pension. It is only pension. Is it not? Do you understand what is a pension with 5 persons, mother-in-law? And when will you have your instructions what has been paid? Half-baked cakes. Huh? Have you heard of a half-baked cake? The cake is half-baked. We are supposed to bake the full cake for you. Is it? Senior, you're at the bar for so long. You are not having your instructions. How can we expect them to have instructions? When? Monday? Monday. At the request of the learned counsel for the petitioner, list this matter again on Monday, by which time the court shall be informed as to the entitlements which have already been received by the petitioner. Full stop. It is seen that although this matter is of 2024 and relates to the payment of extraordinary pension, which is not denied in principle by the respondents, the respondents in the BTC have not yet filed any affidavit in opposition, neither are any instructions available as to whether the extraordinary pension as required by the office memorandums have been paid to the to the petitioner. Full stop. And what does this say? As per para 3 of the said letter, petitioner is not eligible for claiming family pension under NPS.
Yes, Lordship, that
He is
is,
claiming extraordinary pension under your office memorandums.
yes, Lordship.
It's a different issue.
Yes, Lordship. There
Hmm.
also, Lordship, BTC is the authority whether to
EOP
clarify.
will-
Yes, to clarify, Lordship. We are not the
Ah.
authority. We were just asked to clarify.
By the, on the next date fixed, the BTC authorities, namely, more specifically, the respondent number 5 shall have appropriate instructions placed before this court regarding the entitlement of the petitioner to the extraordinary pension as described in the office memorandums. And if the petitioner is found to be not entitled, the reasons therefore full stop. In the absence of the appropriate instructions being placed before this court, comma, this court would require the respondent number 6 and 7 to be personally present in this court on the next date of listing. If you don't have it on Monday, we'll have the other persons coming to this court on the next date of listing. Whether they are entitled to extraordinary pension, and if they are entitled, whether it has been paid, if not entitled, why, and if not paid, why. Have your instructions. This is pension, right?
Lordship, my instruction can be on record.
The instructions placed by Mr. Chodia, non-standing counsel finance, is kept on record.
The matter may be passed over for a timing. Council PR Sharma is in another good lodge.
What is this? What is this? Just a minute. Sure. Yes. Yes. Oh, okay. Where is that order? Your appointment or the impugned order? No, you were unauthorisedly absent. Then what happened? From when to when? Madam, your affidavit is on record?
No, Lordship. Because they, on last occasion, they were supposed to file one additional,
They have filed it.
yes, affidavit, and this has been filed. Now they have to take steps so that we can obtain instruction, Lordship.
Where is your reply? What do you have in your additional affidavit?
Only these things they have brought in, Lordship.
Show cause notice.
Show cause notice. And the inquiry report.
Huh? Where is your reply to the show cause notice? See, again another half-baked cake. The cake is not baked. We have to give the fuel, we have to give the fire.
Lordship, actually, the person who was involved in a criminal
No, we are not on
case,
that.
Lordship, then
Come to page 24.
he remained absent, then the office took the, yes, Lordship.
Page 24.
Yes, Lordship. Yes.
He had given a reply, if you see down below.
We'll have the records and everything, Lordship. I think
Do you have the copies of the writ petition and the additional affidavit?
yes.
You file your affidavit in opposition. By when?
Yes, Lordship, they have to take steps so that we can take up the authority, because this has not been done, Lordship.
Take steps. Copies have not been supplied.
No, no, it has not been supplied, Lordship.
Mr. So-and-so and counsel paying for the petitioner shall supply extra copies of the writ petition on Ms. Bhattacharjee, learned additional senior government advocate appearing for the respondents. For all the respondents, madam?
Yes, Lordship.
So within a period of 1 week from today, the respondents would be at liberty to file their affidavit in opposition within a period of 3 weeks thence.
Okay, Lordship can be 4 weeks.
4 weeks, then 4 weeks thence. We'll stop. The petitioner may file reply to the affidavit in opposition within a period of 2 weeks thereafter. List this matter again on 8th of May 2026, by which time the pleadings shall be completed. The counsel for the respondents would call for and have ready the proceedings
Lordship.
of the records of the department proceedings for perusal of this court.
Deeply. Step full.
Yes, sir. Huh.
Thereafter, I was transferred to New Delhi. The airport in the but people Assam does not provide any commercial service.
Yes.
So thereafter, we find an affidavit and giving our appointment. So there was some huge complaint. Thereafter, there was a physical verification in Sri Bhumi Kachar, because my land and property was there. During that time, I was in the airport of Delhi International Airport. So when they went there, I was not legally present. So I was, because in the promotional period, you take the thing of salary, you go out. The parent agreed, also happened. So one of the, I filed an appeal also, and the termination order is at page 48.
Yes, where is that report? Respondent number 5. Who appears for respondent number 5? And the no, sir. We are going by the last order. They were supposed to get us a report as to whether the petitioner was a voter of that particular legislative assembly. Number 1. Number 2, the Aadhaar card. Who appears for respondent number 1? Respondent number 1, who appears? Yes, your report. Have you seen the last order?
Yes, sir, I have seen the lawsuit. In fact, lordship, I have communicated with Government of India, lordship, and although no, I have communicated the copy of the order, copy of the repetition with the appropriate authority, lordship. Then
what is the response?
Departmental communication process.
I'm sorry.
Actually, one email has been, that communication of the email has been received, sent to me from Ministry of Electronics and Information Technology. What the email contains, sir, may kindly see trailing message for appropriate action. And
We'll take up the matter at 2. Kindly, para 9 of the order. One respondent number 1 is asked to give us an authenticity report regarding the Aadhaar card.
Lordship,
We do not know who is the concerned authority. Respondent number 1 will tell us. 2, respondent number 5, the district election officer of Kachar. Who respond? You represent him, sir?
Yes, my lord, I just placed the.
His name is there.
2026.
Ah.
That is what it says.
No. Verify the authenticity of the Election Commission of India ID card is what was required. Do we require this? This is 2026. He does not say whether the election ID is an original one or not. Huh? Let us have that annexure 4 for a moment. Annexure 4, page 33. Yes. You see, it was. We just need to know whether this is a genuine document or not. Yes, sir. Because 2026 he gets his name entered. That is what you tried to indicate. The 2026 it is there. But this is not a card of 2026. This writ petition was filed in 2025. So it must be an older one. Right?
Yes.
Then respondent number 6. Who is respondent number 6? He was required to file an affidavit.
My lord, additional district magistrate, my lord.
He has filed any affidavit?
No, my lord, he has sent a instruction, my lord.
Huh? What does it say?
My lord, he.
You, sir, have you found out your this thing? Whether the Aadhaar card is genuine or not?
That part, Ministry of Electronics and Technology.
We'll have the Ministry of Electronics and Technology standing here in the court. An Aadhaar card is verified at any point of time.
And what they have pushed the matter to Unique Identification Authority of India, Government of India. And what they have been writing to this authority that may kindly see telling basis for appropriate action. It means the order of the court, with petition, everything, now you examine and give the report. And that email is of 11 February. After 11 February, listen, nothing.
We will have the, we can only ask the secretary, MHI, nobody else. He is not getting a report as we are asking for it.
Yes,
Is it not? We'll ask him to come over.
Basically,
from the same to collect reports from all concerns so that the factual.
He's seeking some time.
After that, the election should not be there.
The thing is that these days, my lord, this district administration, they are so much into election and all.
It is what is your case? Let us see. Where is that report? On the basis of which you were.
In the affidavit we have
Yes.
Page number 97. There are many questions over there. In the last line, is not residing in the above report as per report submitted by the.
Is not residing. And where is your termination order?
Termination order is page number 103.
Huh?
In the affidavit, page number 103.
No, we have one at page 48. Is not residing. Will it be enough? He's not residing.
But that part, Lordship, he is not residing, basically.
He is not residing because he is on duty at Delhi. He is not residing there. True. And the moment you say that this is the reason why we are taking an action against you, is it not that moment that he needs a full hearing?
In fact, Lordship, my
It
brother.
may be true. It may be a fake certificate. Suppose a man produces a fake certificate before you. You don't want that man to be with you.
Lordship.
So you tell him that since there is a confusion, we don't want you. Please go home.
And he's under.
The moment you tell him there is a confusion, he has a right to reply to that confusion.
100.
Or you can tell him that, look, you were on probation. Thank you. Go home. Simpliciter. Go home.
Lordship.
Here you make that sentence. Since there is a physical verification of residential address,
Yes.
and we have received a report that
He's not residing yet.
you are not residing there, he would stand up to say that, sir, this is my electoral card, this is my Aadhaar card, this is my this is my that.
In fact, my brother has shown me that electoral list where his name is there, but that is of dated 2026.
That
This
is why the
But
order
this is of 2020,
the
2022.
the electoral card was required to be verified. He gave an electoral I-card. If it is a true card, this writ petition has been filed in 2025. Prior to 26, you would have the date of issue. You would know to whom it belongs. Is it not? So if he's an elector of that area, we all have family members who are staying outside the state of Assam and they come back for 1 day to vote. But they are domiciles of Assam. They are serving elsewhere. Is it not? So the moment you put it up in this termination order,
What I think is circle officer is the best person to examine and let the court
circle
know
officer is saying that
that
he will not spell it out, but circle officer is otherwise busy.
No, actually, basically, also in other matters, other cases also.
Total
circle officer is
machinery
the-
of district administration is immensely busy.
The immensely busy, that cannot be, Lordship, maybe due to
No,
this electoral.
we'll try to go by the law. Since everything else is failing, let us go by the law. This man has been terminated because his residential proof was wrong. Did he require an opportunity to answer an allegation? Could it have been done in the manner it has been done? Or it should have been done after an inquiry in which he participated? That is all.
Lordship,
We are not on the truth or the falsity of the document.
Lordship, may kindly see page number 102 of the affidavit in operation. That is basically the rules.
That is your claim, Mr. Roy Chaudhary? That is your claim that you should have had an Yes.
Page number 102, it is basically, Lordship, the CIS, part of the CISF rules. Is, point number 4, Lordship. May I just read out, Lordship? Did Lordship find? During the period of probation, he was in probation, or his extension thereof, or as the case may be, the appointing authority may, without assigning any reason, terminate the service of a member of the force on the grounds of furnishing false or incorrect information at the time of appointment of that member of the force, or for his failure to pass the basic training or repeated course by tendering a notice of 1 month to that effect, or 1 month's pay in lieu thereof. So, and Lordship may kindly see.
Now the first sentence is what? Without assigning any
Without
reason.
assigning any reason.
Any reason. In the order you have assigned a reason. That your address is false.
That I think.
If we read this rule, what we understand is you find the address wrong. You tell him, sir, please go home. You don't tell him why you find it wrong. This is how it is to be read. Without any assigning any reason, terminate the service.
Actually,
if you find this wrong.
Actually, in the order, we are not supposed to give that reasoning also.
Therefore, the order goes.
No, if we give the reason,
It
Reasoning.
goes. As per your rule, it goes. If that goes, and if it is wrong, if it is a wrong order passed, the doors for you to take a correct course of action does not close.
Lordship, I want to show this code one more thing, Lordship, page
Please.
number 99, Lordship.
Page number 99.
99. That is, Lordship, the condition, Lordship. Recruitment condition. Roman 13. Roman 13 and Roman 14, Lordship. If there is material evidence at a later date to prove that you had not met any of the criteria laid down for recruitment like domicile, category so and so, education, physical and medical, etc., your provision.
What
your
agreed,
provision-
sir? Totally agreed. We are not saying that he's a person who is supposed to be retained in service. There will be two options. One, once when you are giving a reason, if you give him a reason, you have to tell him that now you answer the reason. This is why we want to terminate you. And if you do it, CCS temporary 5, akin to this CISF, is it not? CISF rule. You don't tell him anything. He goes home a happy man. He can apply
Then
elsewhere.
again, Lordship, again, he will again come that you have terminated me without giving any reason.
He cannot. He cannot, because under CCS 5, temporary service 5 and this rule, during probation, nothing do. We don't want you. That's enough. That is what probation is. But the moment you give a reason, it's a domicile.
Because reasoning we have to give as per this, Lordship, this condition of this recruitment condition as per
your rule 26(4), without a reason, without assigning that reason, you will terminate him if any of the others are found to be at fault. If it is an incorrect information, if it is failure to pass the basic training or the repeat course, you don't have to tell him why you are throwing him out. You cannot tell him.
One more thing, the reasoning is there in that dismissal order, Lordship. And Lordship, in regard to that reasoning, Lordship, reasoning is one of the point that has been mentioned in the Lordship contract, in this appointment contract, Lordship. And Lordship is saying that the order is bad because we have given a reasoning. But that reasoning is basically out of the condition of the contract. So without challenging
you will give you have pointed out the rule.
Lordship.
That other page 99.
Page 99.
99 simply says what you can do. Is it not? That once we find you wrong on this, we'll throw you out. Is it not?
Yes, Lordship.
That is the difference between the termination of service under 311, where you need a full-fledged inquiry,
Lordship.
and termination of a temporary service.
During the period of
Probation.
Yes.
No reasons required. Yes. Even during the probation period, you may want to give a reason. It might be an indiscipline act. It might be a misconduct on which he'll be thrown out. In that case, you give him a full-fledged inquiry and then do it. But if you are supposed to do it as a termination simpliciter 26(4) CISF rules, in that case, the moment you give the reason, the motive and the foundation, the moment you have a reason for doing so. See, a man may not be working properly on probation period. You don't have to tell him you are not working properly. You may simply say, probation khatam, ghar jaiye. Is it not? Probation is that part. So here you are throwing him up on probation because you have received some information. Moment you take it up as the foundation, then he has an opportunity to answer. If it is the foundation.
But the basic foundation is attracted under this point number distinct.
The moment you attribute and misconduct to him, the moment you say, sir, you are a bad man, that is the moment he has a right to answer. The moment you say, sir, I don't want you, he does not have that option. He has to go home. Now here you said you are a bad man. You have given us wrong address. That is the moment he had the opportunity to reply. And that is why this court had gone into finding so much of it on the last order. If the document is fake, forged, anything, this court can wash their hands off. You are not coming up with the reclaim. Your officers don't want us to tell us that. They are writing letters and letters, making it go around. There is a UID, or whatever ID it is called, that Aadhaar card, that number. Is it not?
Yes,
In the airport, in the airport itself, when you go, you place the Aadhaar card whether it is you or not. One liner. They don't want to give us that. They don't want to give us that information.
Others, I basically feel a circle officer is the competent authority also to verify the permanent address. of
So
the person.
we have got the election voter card. That,
That is of 2026.
If he was not here for the last 2-3 years, would he have a voter card this year? Would he have it? Would his name be in the voter list?
This question was arose on to me.
Because he was here. Therefore, his name in the voter list. And therefore, the opportunity to this person to answer. The issue is of an answer. The issue is not of whether the answer is sufficient or not. It may be an insufficient answer.
Opportunity to give
But
a reply.
whether he had the opportunity.
To give a reply. I got your point.
If you tell someone, "Kale pa nalage," let it go. It simply goes. Now, if you are going to a shop every day and from tomorrow I'm not visiting the shop, nothing doing. But if you stand in the veranda of the shop and tell him you are a cheat and I will not come, will you not give him that opportunity of answering whether he's a cheat or not? That opportunity he will have. The moment you give it, you level an allegation against him. Now, in this order, you have leveled an allegation. Tell us, can this stand? Nothing else. That opportunity, whether 24 was complied, without assigning a reason, you will terminate him. If these things happen,
Had he been this point number 13 been attacked in regard to domicile, we are very
24, that where was that page number 99, 10?
103.
103.
No, 102.
102. Page
Without assigning any reason.
Without. If any of these happen, see, if you find that a person, where is it?
No, see, but without assigning any reason, for that the word may is written. May
terminate.
May without assigning it.
May, comma, without assigning any reason, comma, terminate. Otherwise, if you take out the may only with without, terminate goes without and what do we call it? Adverb
The word
or the verb. Now we'll go into grammar. That may has to go with terminate. You may terminate him. Otherwise, the terminate is without the force of a verb. Adverb. I don't know. Whatever it is. May goes without anybody. The terminate word. So therefore, the moment you give him a reason, he would have an opportunity of answering. And if we decide that part, the termination being wrong, the intermediate period has to be considered as something we cannot decide the amount of evidence he will lead in or your inquiry reports.
I think in a probation case, I think it is not.
It is only that simpliciter part. Had it been simpliciter, now with this order, he cannot go anywhere. He had lied about his residency. No person is going to re-employ him. There is an allegation,
The character, yes.
a misconduct. Is it not? That is why it is termination simpliciter. We don't want you. There could be 100 reasons. He'll give his own explanations, but he'll get a job. With this, he doesn't get a job anywhere. And without him being given an opportunity to answer. That is the only question. So tell us.
Oh, only thing.
All the other inquiries that we are trying to make is only to see the genuinity of the claims being made. If we find that yes, he was a resident, if he was this and that, we'll give him all the benefits in the world for his illegal termination.
So what I'll
This is going on a dangerous line.
is lordship disposing the matter to the lordship. Or lordship may just pray, let circle officer maybe given one opportunity.
So they are asking for another month.
I think one we have I think that because the election is on the lordship.
So there is another 2 months. Election, then calculation of votes.
No.
That is the whole thing. That inquiry, he would have the opportunity to answer before you. With food in his mouth. Not hungry. But now he's hungry. He's going hungry each day. Time to. I've always said, when I say on the next date, it is just 1 day for me.
Lordship.
But for that man standing on the other side, it is 1 month.
Time operates different day, different places.
What to do? We can set aside this order, allow you the liberty to have a proper inquiry done, giving him the opportunity, or we can simply say that this is an order, which is not a termination simpliciter. And therefore the order goes. Then we can keep it at that. Or you can come back with an instruction saying, we are withdrawing that letter, giving him an opportunity to answer. And we'll do what is required. If we set it aside, we'll have to think of the consequences. If you withdraw it, we don't need to think about consequences.
But at this stage, it is the picture is gray in regard to the domicile of the person.
If it is a gray picture, how can you take away the job of a person?
No, based on the report of the
If it is gray,
gray on behalf of the state, lordship, gray on behalf of the state, because we have directly acted upon the report of the DC.
see, the simple thing is not residing here. As on that day, he is not residing there.
Then
So prior to that, prior to your coming to a conclusion that he was not a resident on the date of application.
I think lordship, point number 3 will take the point number 3.
Which one?
That giving opportunity to for him to reply against that.
Something has to be done.
Yeah.
Take your instructions.
I'll take the instructions.
This order will not stand. Today or tomorrow, this order will
Will
not stand.
we give him opportunity to
And the
reply?
moment-
Yes.
The difficulty is the moment we decide it, we'll decide the consequences of setting aside of an order. We cannot leave it half done. When do you want it?
1 week time, lordship.
Your reports. Mhm. Now we'll see on the last order, there was some recording by a court, by another bench. We have gone through it. We have tried to find out why it was there. We'll record what we have to. We'll record what we have to. And any court which takes it up, not necessarily time. If we are here the next week, the same bench is here, it will come before us. So we just have to find out that election card from your end. The order requires you only to find out that part. The district election officer has to say yes, it is a proper election card, and the OBC certificate which was sealed. That is at page, OBC certificate is at page, sir? Mr. Roy Chaudhary, the OBC certificate? Yes.
Page 29.
Page 29, 30, whatever. Page 31. Page 31. Is it? Whether it is issued by your office. With all the busyness, perhaps the UD can also say whether it is a proper election card, the number is correct, and whether this was issued in the year 2012. Why should we look into it? When did you join services?
Page 24. 11, 2022.
2022, then this has got no meaning. This OBC paper. We do, huh? It has to be issued every year. You forget this, we are not much concerned with number 3 because it is of the year 2012. But something which was given to you in the 2012, you produced during this recruitment process. Huh?
So, my lord, this recruitment was made.
This page 31 is basically criminal certification. This is not exempt.
This is of the year 2012.
Every year, my lord,
It has to come.
it has to compose criminal with the change of income, my lord, the status will.
And that is okay. Now, we need the election card and we need the Aadhaar card. Two very simple things. Aadhaar card has his address and the election card has his address. Just find, just give us a genuinity of that. Can it be done? Since this order requires you to do so. Mr. Borua,
What direction may be given, so I will communicate to them.
it is already there in the early order. What more directions? The Mr. Borua, CGC. Oh no,
I'm appearing as a CGC also.
you are appearing as CGC, no? Mr. Borua, CGC has sought for a short accommodation to get the information as required by the order dated 3/2/2026 at paragraph 9.1 regarding the authenticity of the Aadhaar card. Full stop. The Mr. Swinson, additional senior government advocate, has Mr. Dhor, has also requested for a short accommodation to verify the authenticity of the Election Commission of India ID card, but has also produced a communication from the concerned officer stating that the name of the petitioner is found in the electoral rolls for the year 2026. Is it? Then this is annexure 2. Annexure 2. The learned counsels have submitted that the certificate annexed at annexure 2 of the writ petition is of the year 2012, and therefore a verification of the same may take some time. Full stop. An accommodation is also sought to bring on record the communication by which the Superintendent of Police DSB had submitted the report on 24/7/2024. Full stop. The affidavit required to be filed containing the information at paragraph 9 within bracket Roman 4 is also to be filed within a short time. Full stop. Do we have that 24/7/2024, or is it there only the mention is there in the order? Where is that order again? This DSB report. Where is the DSB report? Where do you find it?
That was my brother, I think he can DSB report.
Yes, respondent number 6 has to do it. But there is a reference somewhere from where that date has come.
This by the SP lawyer. DSB report is by the on behalf of the SP Kasar Lordship.
No, 24th of July 2024. What is that? What is 24th of July? Page 97,
এটা আপনার এই
last line.
ADC
Okay, then what did we say?
commando kata hai
Full stop. This court has noticed that the order, impugned order dated
14/24. Termination service.
has been issued under Rule 26(4) of the CISF rules and Rule 25(2) of the issue that would further be addressed by the learned counsel for the respondents on the next date is as to whether the inclusion of the reason for termination in the termination order itself was in sufficient compliance of the provisions of Rule 26 or 24,
24.
Rule 24,
26.
Rule 26 within bracket 4 of the CISF rules 2001.
2001.
2001?
Yes.
2001. Stop. Let this matter be again listed on 20 March.
Someone maybe already.
24th or the 25th of March?
Yes, yes.
25th of March. The instruction produced by Mr. Dhar is kept on record. Yes, sir.
My lord, your lordship kindly accommodate me in item 30.
Yes, sir.
Lordship take it tomorrow, my lord.
Item number?
32, my lord.
32.
I have taken consent of my learned friend also.
Yes. Friday. At the request of the, it's Friday, okay, sir?
All right.
Item 32. Place this matter again on Friday. Huh? Friday will be 13th, huh? 13th of March. Okay.
God bless.
Thank you. Huh. Huh. At the request of the learned counsel for the petitioner, list this matter again on Friday. Huh? Oh, on 16th. 16th. Ah, okay. Yes. Which is the order? Ah. Page 17. Ah. What is the reason? Yes, why discharge?
Sir, he has requested for discharge, lordship, at his own request, he was
Where do we find it?
lordship.
Where do we find that document?
Lordship, at page 53, lordship, discharge
Page
for service at
53.
own request. 53. Discharge from service at own request in respect of has been approved with effect from 31st December 2023.
Murugan V for discharge, own request. Ah.
This is for interview of the company.
Here, nothing is to annex to prove that AS has been interviewed successfully. But I'm not able to speak, he doesn't have a signature of the pensioner also. What did you say? no signature of.
Hmm.
Complete value plus 46. Here you lordship has only come to your signature of the petition. There is no signature. Here itself.
Where?
Is 46 alone.
Huh?
There should be a signature on which they get signed. Discharge from service at home request.
Huh.
46.
Huh.
Lordship has already gone through all these aspects for the last year.
Huh.
This, my condition is that I was forced to sign on a printed form.
On 9th of March 2022. Okay. Ah.
48. Here is the recommendation of the board of commandment. There is no signature of the petition here also. Recommendation of the board, yes, there is the signature of the petition that is continued. Moreover, now the lordship can will come to para 4. Take the recommendation of the board. On examination of the application and service group of the individual, it is established beyond doubt that the request for retirement. Whereas they are saying I have requested for discharge. Now they are saying retirement. Is genuine for future benefit of the individual. Therefore, the board recommends that this is to process for discharge from service. They are saying about retirement. Yeah. If the petitioner on the my service is more than 19 years. After 20 years, you will
No, you have completed 17 years. Page 17. Huh?
After holding 15 years.
Huh? That is on the date of on which you are supposed to retire. It is on 31st of December 2023. But when you applied, it was 17 years.
I did apply a lot. I never applied for a uniform discharge. This is my concession. I never applied. It was forcefully done on me. They forcefully given me this discharge.
Now, when your signatures were taken, did you not make any objections whereby blank paper signatures are being taken or?
The officers then will be to sign this for your benefit. I didn't think about all that stuff regarding to discharge. Now it was informed to me that I will be discharged from service.
Why would they do it? Why would they want you to be discharged? No. Doesn't happen like that. There must be some reason. You must have had a fight. You must have not been attending duties. Something you are in shape 1 also. Shape A3. A3 why? When?
My knee was fractured, left knee. That was the reason. NOC.
Just a minute.
Not by any, for I applied for discharge from service before completion until that my only no person. Just by the authority itself, not by my family members, that you go for discharge. NOC was also submitted with what they were saying. It was not known to my family members also.
Can these things be decided in a writ court now? Huh? Huh? Huh?
These are the benefits you will get if you go for charge or process given to you.
But they are showing that there was an interview. There was an interview on 7/3/2022. Yes, madam, he files an application on 9th of March. And you interview him on 7th of March? Why?
Initially, he sought for the interview of the commandant
Good.
on 7/3/22. After interview lordship, he submitted application for discharge.
Okay.
So,
Then
as per the procedure,
after submission of the
after interview,
after he submitted the application,
he
was
submitted
he thereafter was he thereafter what do you call that? Was he given any consultation
Yes,
that
lordship.
this is what you lose, this is what will happen to you? Where? Where is his presence? Just a minute, sir.
In our affidavit lordship,
No, in your documents.
documents lordship, in our affidavit in
Yes.
1/3 lordship, 32.
Where is that board of officer?
Board of
Yes. Okay. Then the board of officer, they meet on 28th of March. They are supposed to give him the consultation and everything.
Yes,
Is it not?
17 March, it was constituted, board of officers was.
They met on 28th March.
Yes, on 28 March.
Now, this no objection certificate is what date?
After interview of the petitioner, the board recommended his discharge from.
Are you saying that you never appeared before this board? Then?
Lordship, after that, he has submitted no objection certificate, but in the meantime, he went for lordship, went on leave lordship. During leave period, he lost the identity card. Therefore, there was a court of inquiry, and therefore his research was our lordship. For some time, it was stopped.
It was kept.
Yes. After that, again, he submitted an application for research. Thereafter, again, he submitted
When?
an application at 51. Yes, 51, that's it. This is for interview of the commandant. 25 serial number, Murugan, for discharge from service on request. Second time, he again submitted application for discharge. Then 52 is willingness certificate.
Second.
Yes, lordship, second. And thereafter this 29 September 2023, this discharge order was issued. Yeah, applied twice, lordship, for discharge.
Page? 48. We are not finding much. Acha, this recommendation of the board and all. Yes, madam. You have acted on the second discharge.
Yes.
Where is the second board?
Second board not constituted.
Then goes.
But since earlier board has already recommended.
No. When you accept the second, this thing, when you accepted this, you need a board.
2023, 29 September 23.
You have taken into consideration his second, this thing.
Yes. First, application, he was recommended for, his research was recommended lordship, but due to pendency of the court of.
You have the
adjudication,
records.
No lordship.
Kindly see page 53. 1 serial number D.
35 year representative.
1 serial number D, C and D. What are these two letters?
Willingness certificate, no, this is by 30.
21 September is.
Yeah, willingness certificate.
Kindly bring the entire file.
Yes.
Bring the record
Friday. I have
on his record. Huh? Monday.
I'll produce a record.
Just I want to point out what is proceeding. Recommendation of the board, what they have said. Not the request for retirement. They are saying discharge. There is retirement. I am under the impression that I am going for retirement. That is the problem here.
But you said that you do not even know what you are signing.
Yes.
And how can you retire before 20 years of service?
I'll produce a record. Sir. Monday.
There's a judgment of the division bench. This discharge and retirement. Mr. Gupta was. That was BSF, if I'm not wrong. It's a matter of BSF. Justice, my Lord Justice UK Nair perhaps was one of the judges in the matter on the bench. It was relating to BSF. The question was of discharge and retirement and what is the procedure to be followed. It goes against you, but there is a judgment. At the request of Miss RDB Learned Council under the Central Government Council for production of records relating to the processing of the case of the petitioner for his discharge / retirement / resignation. List the matter again on 16th of March. Yes.
We need some time to file affidavit, lordship, on behalf of private respondent, lordship. 4, 6, 9, and 10. Already government has filed. Already government had filed the affidavit. In support of that, lordship, we will also.
What is this matter relating to? You want to file your reply for?
Affidavit in support of government, filed by the government.
Respondent number?
4, 6, 9, and 10.
4, 6, 9, 10. And what about the others? 1, 2, 3, and 5?
5, Dati service has been completed by the
None appear.
Till now.
Okay. Mr. So-and-so appears for the petitioner. You are appearing for 1, 2, 3. Ms. So-and-so on behalf of Mr. Dinat, learned senior government advocate for the respondent number 1, 2, and 3, who have filed their affidavits. Your name is?
DJ Bora, lordship.
Mr. DJ Bora for respondent number 4, 6,
9, and 10.
9, and 10. Praised for some time to file their affidavit in opposition. Respondent number 5 has been served by Dusty, but there is no appearance on his behalf today. What about the others?
Rest service all completed.
But until that, no one has.
None has appeared for 7, and you are appearing for 4?
6, 9, and 10.
4, 6. None has appeared for 7, 8, 11, 12, and 13. Although it is stated that the service has been completed upon them. Good stop. Where do we find that it has been? Ha. 4, 6, 9, 10. What about the rest? Oh, yes. All completed. Full stop. List again on.
Sir,
We'll have it on, huh?
1 week, 2 weeks,
2 weeks.
after 24.
We'll have it on the 30th. 30 March. You can file your reply by then. The petitioner would be at liberty to file the response.
Then beforehand, I oblige my.
Yes, sir. Hmm.
I think 35. That is 2023, madam. Two repetition to a repetition. What happened, madam? The repetition is annulled.
Hmm.
And the private respondent here.
Huh?
Private respondent here. Says reserve candidate.
Hmm.
In the year 2010, private respondent was promoted before the promotion of the repetition.
Hmm.
Well, I need to tell you the merit list, merit list is at serial number 6.
Hmm.
And the private respondent was at serial number 12.
Hmm.
The last person in the merit.
Hmm.
Thereafter, what happened, father? During the pendency of the earlier deed petition, in the year 23 February, there was one DPC,
Hmm.
Department Selection Committee,
Hmm.
held for four posts
Hmm.
of Joint Commissioner of Taxes.
Hmm.
And minutes of the DPC, your lordship will get in the page 327 of the affidavit filed by the government. While filing the repetition matter, the copy of the minutes was not furnished to me in spite of my happy arrangement.
Hmm.
Now kindly come to page 327.
Hmm.
That is the DSC meeting dated 4/2/23.
Hmm.
And then is it available? Kindly come to 4. Towards bottom, main in position at present 1.
Hmm.
And existing vacancy is 4.
Hmm.
4 number. My lord, then kindly come to next page, 328.
Hmm.
The roster point of the existing vacancy followed RP number 4, RP number 5, RP number 6, unreserved, and RP number 7, unreserved.
Hmm.
Now, the petitioner is at serial number 6, and the private respondent is at serial number 7.
Hmm.
My lord, why, my lord? During the pendency of the earlier case, there is one wave came into force. That is when dated 18/1/2023. My lord, that wave is part of the repetition. I will place that. Before that, my lord, kindly tell you. Kindly tell you the next page, 329.
Hmm.
329, column E and F.
Hmm.
My lord, stands here now. Just the ruling of this High Court that in the federal state of 5 or 4 or 7, there cannot be reservation in promotion. Why, my lord? Because if we have promotion, reservation in promotion is a payment. To a stop, no result. Here, my lord, kindly Kindly peruse E. 320. Kindly peruse E. The committee discussed the Honorable High Court judgment dated so and so in WBC 3581 of 2015, wherein the Honorable Court had directed that the promotion from Deputy Commissioner of Taxes to Joint Commissioner of Taxes shall be carried out on the basis of recruitment rules in force without any additional weightage of on reservation as provided under the Reservation Act as amended. Now come to clause F, madam. How it was dealt, madam, by the respondent authority. Further, WPT and BC department has allowed also viewed in so and so to continue following reservation provisions as in 13-point roster on rotation basis in the cadre of Joint Commissioner of Taxes, subject to maintenance of reservation within prescribed percentage of 22%. Representative from Tribal Affairs Department affirmed the committee that department should follow 13-point roster on rotation basis in the cadre of Joint Commissioner of Taxes. This WPT department overruled the judgment of your lords. Madam, then we come to page 330. Clause I. The committee, accordingly considering the relevant aspect, recommended the following officers for promotion to the cadre of Joint Commissioner of Taxes from the cadre of Deputy Commissioner of Taxes, subject to leave of Honorable Gauhati High Court as may be necessary. The respondent number 4 is at the private respondent is at serial number 4. Now, my lord, kindly take this sentence, my lord. In case of three so-and-so who has been recommended for promotion against roster point number 5. So this shows that in the cadre cell of 5, they are following the roster point. This is unheard of. The judgment I will place, there are near about 5 judgments of this Honorable High Court declaring that in the cadres, lower cadre cell, that is 4, 5, 6 or 7, there cannot be reservation in promotion. But they clearly violating those laws laid down by your lordship, they follow the roster point. Now, my lord, during pendency of the case, my lord, during pendency of the case, my lord, the lead petitioner was promoted. I have filed one additional affidavit on 21/1/2026, man. Kindly come to that, my lord. My lord, why I am arguing the matter, my lord, at page 345, man.
Yes.
Page 345, man. Here, my lord, by this order dated 3/12/2025, the lead petitioner was promoted. Now, my lord, what the respondent authority wants to do, my lord, they want to promote him. Now they are saying that yes, the lead petitioner was promoted. Now, they want to promote the private respondent from the year 2023, and they kept this post for him. I place them. My lord, everything is unheard of. I could not annex this one by your affidavit. Kindly tell you. I not of my promotion. They furnish this man. Here, my lord, kindly see. Presently, a single post has been kept vacant due to Honorable Gauhati High Court order. There is no such order to keep a post vacant for the private resident. Presently, a single post has been kept vacant. Honorable Gauhati High Court order. So was recommended for promotion to the cadre of DCT from DCT in the DPC meeting held on so. However, DPC had directed that due to direction of the Honorable Court, promotion would not be made to him without the leave of the court. Letters have already been written to standing counsel to pursue them. So, my lord, so my lord, they want to place him of me by promoting him from the year 23. My grievance is this, my lord. Yes, let there be a DPC, I will agree to that. Let there be a straight DPC. My lord, now kindly come to the law laid down by this honorable court in the cadre of Joint Commissioner of Taxes. That is the judgment, my lord, related to the roster point of Joint Commissioner of Taxes, and it was held that no, there cannot be any reservation in the cadres of Joint Commissioner of Taxes. Kindly come to page 80 of the report. Annexure 50.
Yes.
My lord, relevant start from para 21 onwards at page 84. Before that, my lord, I am placing para 1, my lord. Kindly come to page 81. By filing this writ petition under Article 226 of the Constitution of India, petitioner seeks passing of notification dated 8/3/2013 issued by the Commissioner of and Secretary to the Government of Assam Finance Taxation Department laying down post-based roster in the cadre of Joint Commissioner of Taxes under Finance Department, and further seeks a direction to consider the case of the petitioner and other eligible candidates in the cadre of Deputy Commissioner of Taxes for promotion to the cadre of Joint Commissioner of Taxes without applying.
Okay, we have read it.
Madam.
We have read it.
Madam, kindly come to paragraph 23, madam.
We read the opposite, we read 32. We have read paragraph 32 also.
Fine.
Yes.
Now the law is well settled. And kindly tell you paragraph 25. In the paragraph 25 of page 85, there, my lord, one judgment of Devakumar Datta. This court, after taking into account the statutory percentage of reservation for 3 categories, SC, STT, and STA, held that in the cadre of additional chief engineer in the water resource department, having cadre strength of 7, 10, and 5%, would come to 0.49, 0.70, 0.35 respectively. It was held that no post could be reserved for any of the reserve category candidates in the state cadre, as it would exceed the prescribed percentage of reservation provided to each of the reserve category. Now, my lord, this judgment of the single judge, my lord, was taken up to division bench.
Hmm.
Next paragraph, paragraph 26. It appears that against the aforesaid decision, a writ appeal was preferred in the case of the so-and-so. The division bench not only upheld the view taken by the learned single judge in Devakumar Datto, but also held that clubbing together the entire percentage of reservation of three reserve categories for the purpose of finding out the quota of reservation fixed in a cadre for the purpose of promotion is wholly not permitted. And finally, one more. This is the various notification of the rules, service rules. Admittedly, admittedly, the selection was made on 4/2/2023. That is annexure 8 at page 327. They are affidavit. Yes, the selection list dated 4/3/23. And we are now in 2026 month. And what the service rule says regarding list for promotion. Finally come to rule 12. Rule 12 read as general procedure of promotion. Yes, before that, my lord, Joint Commissioner of Taxes, your lordship will get rule 5. I know your lordship can go fast, my lord, but still I am trying to cope up. Rule 5. It's Rule 5, Roman 2. Recruitment to the service shall be made in the manner prescribed hereafter. Recruitment to the cadre of Joint Commissioner of Taxes shall be made by promotion from the cadre of Deputy Commissioner of Taxes.
Yes.
Now come to Rule 12. General procedures of promotion. Before the end of each year, the appointing authority shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year in each cadre. The appointing authority shall then furnish the committee the following documents. I am my lord, kindly peruse Rule 11.
Select list shall remain valid for 12 months.
Well,
Okay.
my lord, the law is my lord, after expiry of the select list, they have no right. The case of the private respondent can be taken up afresh for promotion because they are keeping a one post vacant since 2023. A post like Joint Commissioner of Taxes. There are total 5 number of posts throughout Assam, but they can keep one post vacant for the last 3 years. Why, Malak? To accommodate the private respondent. He is so powerful, man.
Or he is so deserving.
Yes, man, very deserving, man. I agree to that, man. Very deserving. Now, Malak. Malak, it is well settled, Malak. No mandamus can be issued when the rules are there, and contrary to the rules, no mandamus can be issued. Or my lord, the case is pending since 2023. We are trying our best, but the matter could not be finished. These are the three judgments, my lord, of this court, my lord. Wherein it was held that in the cadastre of 5, 7, or 4, there cannot be any people. These are the done.
Okay, that is all we have to decide.
My lord, meanwhile, one thing I have to place, my lord. Meanwhile, the OM dated 18/1/2023 was challenged by the private respondent.
18/1/2023, where do we find it?
That is, my lord, in the writ petition. Yes,
Yes, 110.
yes, ma'am. 18/1/2023, 109, my lord, and it's 18. ma'am.
Yes.
This OM kindly peruse to come to clause 4A. I have to place this, my lord. For when provision has been made for catch-up. Catch-up rule, that is, your lordship will get in the 5th line of clause 4A. May I have?
That was challenged. What happened to the challenge?
My lord, the challenge was set aside, my lord, and by this judgment,
Challenge was rejected.
they went to the division bench, no stay order, matter is pending. Before going to the judgment, my lord, I also place one thing from the OM, my lord. Kindly come back to OM again once again, my lord, at page 109, my lord. The last paragraph of clause 4A. If an occasion arises during the promotion process in Group A service, in which stipulated percentage in respect of reserve category is made in the next promotional grade, but in zone of consideration, there are candidates of reserve category who, on merit, are entitled to the promotion. Their cases shall be considered for promotion on merit if such candidates have not made into zone of consideration by way of accelerated promotion earlier by virtue of rule of reserve. So, this clause, basically the respondent numbers, private respondent, challenge the way on this clause, clause 4. And what the court in this judgment of Rajesh Lamthasa, court held that finally come to paragraph 53. Therefore, the consistent views both by the apex court as well as by a division bench of this court having held that the state is within its liberty to grant or not to grant the benefit of consequential seniority during promotion of reserve category candidates, the impugn of OM dated 18/1/2023 bringing the policy of catch-up rule and superseding the earlier policy of consequential seniority can be held to be bad in law. Cannot be held to be bad in murder. Then paragraph 55, that apart from the second part of clause 4A, is parameteria with clause 4 of the earlier OM, dated 3/8/2016, and which provision has already been upheld by the division bench of this court in IV Gauhati Dasgupta case. The division bench had declined to interfere with clause 4 of the OM dated 3/8/26. This judgment of division bench has not been subsequently assayed, and therefore the same has attained finality. Consequently, the findings of the division bench of IV Gauhati Dasgupta are equally binding on this court. In view of all the above,
Yes.
Okay. And today, this judgment that when the rules is there, no maintenance will be issued. Basically, I have no given. There be express consideration of the case of the private person. But he cannot be put. He cannot be promoted from that date. 23 February 23.
That is the challenge in your
Yes, ma'am.
the first read petition.
Second read.
Huh?
That is the present read.
What was the earlier read petition about?
But my lord, basically, at that point, they want to promote the private respondent. Then I approached the court, and the court granted stay. Without leave of the court, he may not be promoted. In spite of that,
They went ahead with the DPC. They went ahead with the DPC. In the DPC, they wanted to promote him, but because of the stay order, they could not. In the meantime, you came back to this court. Okay. Yes, sir.
Lordship, may I draw my Lord's attention at writ petition 4319 of 2021, Lordship. That is item first.
Why don't we stay on the writ petition that is being done?
Lordships, I'll have just to take my Lord to the prayer which has been made over there.
Oh, we'll discuss
That
it.
prayer relates to final gradation list that has been challenged in that writ petition for the year 2021. Subsequently, Lordship, the development has so happened that 18/1/2023 a fresh OM comes in. We are all governed by the fresh OM of 18/1/2023. That was challenged by reserve category candidates. That was not allowed. Went to the division bench. The matter is pending over there. 18/1/23, Lordships. There is one more judgment by this honorable court. If I may please, my lord. That it says the status of the parties prior to 18/1/2023 will not change. So the seniority whatsoever may be, Lordship, para 12 of that judgment, Lordship, may kindly peruse.
That is
130 of 2024. Writ petition. It is relevant to take note that a perusal of the office memorandum dated 18/1/23 stipulates that the office memorandum would come into force immediate effect. Consequently, the office memorandum 18 months.
How is it relevant?
Lordships, my position as of 23, Lordships, in the cadre remains, Lordships. And prior to that,
That is what we had challenged.
Lordships.
Your position prior to 18/1/23 is what he has challenged in the earlier writ petition.
Lordship, prior to that, we were having consequential seniority and an office memorandum of 3/8/2016. That was operating, that was upheld in one of the judgments of our High Court, 5005, that is Bhagwan Patta versus Shekhar. That upheld that consequential seniority we are entitled. To overcome that fetter, Lordships, 18/1/23 was brought. Our division bench, while this matter of single judge of Bhagwan Patta was challenged in the division bench says, yes, the office memorandum of 18/1/23 will be there, but consequential seniority cannot override that. So, my lords, my
Consequential seniority
to the petitioner. I was the petitioner. My consequential seniority will not be overridden. Consequential seniority remains because office memorandum of 12/3/2002 that was brought in pursuant to the 85th Amendment of the Constitution, that was never withdrawn. That was the finding of the division bench of this Honorable.
Where is it?
Lordships, I'll just take my lot to that judgment also.
Let us,
That is
let
part
us
of-
get, let us get the facts straight.
Lords,
There was an office memorandum of 2002,
Lords,
which says
consequential
that
seniority.
if a person is promoted under the reserve category,
Lordships,
he
means
retains his
consequential.
seniority over the other unreserved category candidates who were promoted later on.
Later on.
He remains a senior.
He remains in Syria and he gets consequential promotion in terms of the roster.
Uh-huh.
Roster was upheld in R.K. Sabharwal's case in the year 1995.
Now, do not
Lordships,
deviate from what we are trying to understand. We will
Lords.
go here and there,
I'll try my best. Lords.
and there will be no end to this.
Lords.
So once that consequential seniority you retain as per the 2002
Office memorandum.
office
Lords.
memorandum,
Lords.
when you are now considered for the next promotion,
Lords.
which I think is under challenge in the that gradation list,
Gradation
which
list
will
of-
result in the next promotion, has been challenged by the petitioner in the first writ petition.
Correct.
That writ petition pending,
Correct.
that was in 2021.
21. Lords.
Prior to that, something in 16.
3/8/2016, there was one office memorandum
Huh?
that says the promotion, the state will continue with the reservation in promotion.
Huh?
So, Lordship, so far as this judgment was that
You were safe.
we were safe.
Huh?
Division bench in page, if I may take my lords to that judgment, I'll
Huh.
just read out, my lords. I'll not trouble my lords. I have filed this affidavit in opposition.
Hmm.
My affidavit in opposition contains that judgment of the division bench, para 37, page 234.
Hmm.
Accordingly, it would have to be concluded that a conjoint reading of clause 1.11 and clause 14 of the office memorandum 12/9/14 would mean that the consequential seniority that was otherwise meted by the office memorandum dated 12/3/2002 has
Hmm.
not been withdrawn. This
Hmm.
was the finding of the division bench that says consequential seniority we are not into. It has not been withdrawn.
Hmm.
So long it has not been withdrawn, it continues.
Hmm.
Because this division bench judgment came pursuant to a single judge order, that was Bhagwan Patel, that has upheld this. The consequential seniority, all are entitled until and unless it is withdrawn by the state. So, my lord, we are confirmed this judgment came in the year, lordships. That is writ appeal 46 of 2023. Judgment arrived in the year.
Where is it?
Lordships, page 200 and Lordships, it is in my affidavit of opposition in
In which
3555 of 2023. 3565 of 23, lordships.
you asked us to open the other writ?
My lords, there,
Eh,
my lords, because this came subsequent, lordship. This judgment came subsequent.
we are tired people, don't
Lord-
do it. Yes. 280?
213 lordships. That is judgment of 10/8/2023.
Hmm.
May I take my lords to page 214 for a moment, my lords. This idea of consequentiality, where it came from, lord, that has been noted in this judgment as well. 213 is the date, my lords, 10/8/2023. That is pursuant to the office memorandum of 18/1/23. Now, my lords, I read para 4, that is at page number 214. After the 77th and 85th Amendment to the Constitution, the Government of Assam through the Department of Personnel, we had issued an office memorandum under the signature of Commissioner and Secretary to the Government of Assam in the personal bearing this and this dated 12/3/2002, providing for consequential seniority to the scheduled castes and scheduled tribes government servants on their promotion by virtue of the rules of reservation, and the office memorandum clearly provides that such provision was consequent upon the amendment of Article 16(4)(a) of the Constitution of India by the Constitution 85th Amendment of 2001. In other words, it has to be understood that by virtue of Section 5 of the Act of 1978, the provisions for reservation and promotion to the reserve category candidate was already introduced in the state of Assam prior to 77th Amendment to the Constitution, whereby the office memorandum dated 12/3/2002, even the consequential seniority upon such reservation on promotion being acted upon was also pursuant to the 85th Amendment of the Constitution.
Can I make one statement? This is not relevant because Because kindly consider the CPC report, man. My position was above him and that has not been settled. And kindly, there is a gradation list of 23 where I was made senior
This-
to him.
This can be done after he finishes, sir.
My dear.
This can be done after he finishes. We'll definitely hear you again.
Valuable time of the lordship. That's why I am placing that one.
But if we keep cutting short, they will have a grievance that we have not heard. The heard part has to be there. Yes.
Lordships. So Lordships, I'm continuing with that affidavit in
Ah.
opposition. May I draw my Lord's attention at page 247 for a moment?
Were you being given this promotion, which is now under challenge, the promotion that is sought to be given to you? Is it because they have applied a reservation to a 5.5 cadre thing,
Point.
or
Proceed.
because you are senior to him?
Lordships, seniority has to be seen cadre-wise. That law has been settled. I have a judgment. Amarjit Singh,
I am
that's
asking
it.
you a very plain and
Lordships,
simple
correctly,
question.
Lord. Fifth point roster.
You were
that's it,
there
Lordships.
in
I
the
was
select
always
list.
senior.
In the select list, you are there.
I'm there.
He
Senior to
remains above you on the merit.
Lordships,
You are being about to be given the promotion over and above him because there is a reservation for an ST in a 5-post cadre.
Lordships.
Can there be a reservation in the 5-post cadre? Number one. Number two, if it cannot be there, divorce that. Do you stand still senior in gradation and in merit to him to be given a promotion before him? Just answer that.
Correctly. It has to be given because, my Lord, I was always senior to him in terms of the office memorandum of 2002. I was already always senior to him, my Lord. in
Where
all
is that?
cases.
Where is that part
Lord.
which says that? Where is that list?
Lordship.
Let's select list.
Select list which is under challenge, Lord.
Which is not under challenge. Which is under challenge.
Lordships. Your Lordship will find it in
Page.
writ petition 4319 of 20.
No, we'll find it in writ petition
4319, Lordships.
3565.
3565.
It was there in 3565. He showed it to us.
Page 320,
Yes.
Lordships, I'll just look up there.
by the affidavit of the state.
Mr. Betala,
Lordship.
can we have it this way? We are not going back to the first writ petition.
Second
We'll
one.
be
Lordship,
always
I'll
on the
concentrate
second writ
on that.
petition. Which one? Page 3?
327. Annexure 70.
A selection shall be made on the basis of merit with due regard to.
Seniority.
So when the merit is more,
Seniority will come.
Eh?
With due regard to seniority, Lordships.
when the merit is more,
Merit is more. Merit will be given precedence.
so if the two of them
Two
have
of
the
them
same
will
merit,
par. Merit will be given the
now
seniority.
let us come to that list.
Page 78 of the writ petition.
Just a minute. Page 70?
78 of the writ petition, Lordships.
No. Where is your merit, sir?
Lordships, I
Your
stand at
merit
serial
is.
number 3, Lord.
Just a minute.
And his name appears at 11, Lordships. Writ petition, page 78.
Page 70?
8, Lordships.
This is the gradation list.
Yes, ma'am.
For the year 2021, my Lords. I was always senior to him. My name stands at serial number 3. His name stands at 11. In the
Now we
grade
are
of
asking that
deputy
this list prepared on at page 328.
320.
At page 328, at page 328,
Lordships.
there are 8 officers, numbers, serial number 6.
6 is Santanu Dhar, 7 is Kamleshwar Lahiri. Lord.
Why are you one step below him?
Because of lordships 18/1/2023 effect of that OM.
Huh.
We were brought down,
So now 18/1/23 has been upheld.
has been upheld.
So Santanudhar remains above you
He remains above me.
as,
And he has been promoted also.
no, he
Me-
remains above you.
He-
Then where is his merit being assessed? In that,
Lordship, at page 329, my number at serial number 5.
where is his assessment? He was not assessed in that.
Shantanu, Lordship, with
Why was he not assessed at C? So therefore, let us first have the person who had done it. Is it not? The person who had done all this. Better to hear
will
him
be
first.
answered.
Of course, your promotion is at stake. But it has
But
to be done
that's-
correctly by the person who is supposed to do it.
Milord,
So let us hear him first.
maybe.
Well, regarding the gradation list part level, may I place this document? It's not part of the report. Yes, place that provisional gradation list, this is the final gradation list, madam. In the post of Deputy Commissioner of Taxes. Where from, my lord, the next promotional post, that is Joint Commissioner has been given.
Hmm.
Lordship will see, my lord, the petitioner is now above the, my lord, private respondent.
Hmm.
And that document that was placed, my lord, that is a provisional gradation list, not a final gradation.
Okay.
So now it is
Challenges
clear,
to
my lord.
provisional gradation list, we are doing away
Yeah,
with it.
now, because if the final has come up, so if at all any grievance is there, since he is now above the.
No, no, we are not on that. What we are trying to find out is this. Then is it your stand that this minutes of the departmental selection committee held on 4/2/2023, you are not giving effect to it?
Well, yes, 2023.
You are not giving effect to
There
it.
is an order, my lord, passed by his honorable court.
Without leave, you cannot give.
Yes,
Are you saying that you will not give? We close the writ petition happily now.
my lord.
We will be so happy to do it. We don't have to decide anything. This is the bone of contention. See, 5 posts in a cadre.
My lord,
He is showing us the law. No reservation.
no reservation, my lord.
That is settled.
My lord,
Now, in this 327, page 327,
yes, my lord, I think holding it.
have serial number 6 at page number 328.
Yes, I have seen.
Numerical.
Yes,
Santanudhar is above Kamaleshwar Lahiri.
my lord,
No problem on that. That is what you have done now. Is it not?
my lord.
So he remains above. Now, if you come to C, the clause C, the end of the page,
Parasi, yes,
you will find Ornima Chaudhary, Gaurango Ghosh,
my lord.
Anjurani Boshyo, Anil Kumar Jalan, and thereafter directly Kamaleshwar. He goes missing. Why does he go missing? 4 are for unreserved,
My lord.
and 1 is for reserved. Could not have been done.
Pursuant to that, my lord. I
Could
can-
not have been done. If could not have been done,
Well,
this entire recommendation goes.
the lordship will see, my lord, I for a moment, my lord, para I.
Yes. You took in 5 persons under consideration, and you have given 1 reserved. That is the only issue. There are 5 posts in that cadre.
Yes, ma'am.
Could 1 be reserved for an ST category candidate?
Following Rakesh Agrawal's case.
If not, then it has to go by merit. The merit being equal, senior.
My lord,
Is it not?
my lord.
That is how we are understanding it. We may be wrong. If that be so, his merit was never assessed. On the basis that one ST person has to be assessed.
My lord.
Are we wrong? If RK Agarwal, who fortunately was perhaps member number 5,
Lordship will kindly see, my lord, page 320.
who is member number 5, take note of that also. At page 327,
My lord.
member number 5.
Lordship will see 329 for a moment.
3?
329.
Hmm.
Lordship will see, my lord, after the chart, ACRs of the last consecutive 5 years of so-and-so Santanadhar, that is a petitioner hearing,
Ah.
are not available in the department.
So
It was not.
why should you are holding the DPC? You will collect the APRs. They will collect APRs for themselves
ACR.
and go to the department. Sir, I have all my APRs with me, all the ACRs with me. Can they do it? This is not a big issue of reservation, not the way we are seeing it.
My lord.
He's taking us to so many different cases.
The following my lord, yes, Rakesh Agarwal, my lord, of course, it's
Huh?
very clear.
If
That-
R.K. Agarwal, his case was not to be considered prior to him. And two reasons for, one reason for considering him, one has to be an ST.
My lord.
Is it? Reason for not considering him?
No.
His ACR is not available.
Senior. Otherwise, my lord, at that point of time, he was a senior most, my lord.
Where? How?
In the cadre wise, my lord, yes.
How? To show us at number 6, we see him below Santanudhar.
No.
Page 328.
27, 28, this is not a gradation list, my lord.
Everybody else is in the seniority. Ornima is Ornima, Goranga is Goranga,
There are 8.
Anju is
number of
there,
people are
Anil is there.
18,
Everybody is on that, according to that list.
18, 123.
Hmm? And then this F says that no, we will apply roster.
My lord.
Despite R.K. Agarwal, we will apply roster. Can they? We are poor on law,
My lord.
but we like the facts straight.
My lord, subsequent to this, my lord, when this particular minutes was under challenge, what is honorable court in the secondary petition, there was a DPC lordship will see, my lord, the one loose copy has been submitted to the court.
Yes.
There, my lord, subsequent to that, the case of the petitioner was considered.
Happily.
He has been
Happily,
now
no one.
promoted. Yes.
He has been promoted. There is no difficulty. His only anxiety is if you go ahead with page 327 and all,
My lord.
that DPC, if you go ahead with it, then this man gets the benefit from 2023. Why? Because as per the RTI, you have kept one post vacant for him.
No, in fact, it is minor, it's there in the minus also.
So one post has been kept vacant for him. Moment this writ petition is closed without there being a discussion on 422023,
Yes.
he again takes a ride over him. He will be again running after that carrot tied before him. He will keep running to catch the carrot. He will never be able to. We just need to know, can the roster be applied? If not, Mr. Gogoi,
My lord.
just have your instruction on this. Page 329. E and F.
Yes.
Is F trying to override E? If F is overriding E,
Okay, so you will.
then we'll have to set aside F.
My lord.
If F goes, his
Consider.
consideration by the DPC goes.
My lord.
If that goes, 422023, so far as it relates to the private respondent goes. We close the writ petition by that, leaving things to take care of themselves.
My lord.
His new recommendation, his new promotion, all will fall in line. 5 posts,
My lord.
no reservation, no roster point, plain and simple. That is what we have understood.
On everything.
Whatever was his seniority, whatever was not his seniority. 422023 saying that we will maintain the roster even in 5 posts. Therefore, we consider him. If his consideration is otherwise than F,
Yes.
then we uphold 422023. No problem. If his consideration is only because of clause F,
My lord.
then it has to go. The moment it goes, we leave, what do you say? Natural consequences
Yes,
on the
will
board.
follow.
Whatever is there. Mr. Betala, can we confine it to that?
Lords will have.
Instead of a 34-page judgment, we'll confine it to that.
Even by.
If your seniority was the consideration, if your seniority was the only consideration for 422023, nothing wrong in that. But if F was the requirement of, if F was the basis for your consideration, then it goes.
Only on that point I will have the clarification. If it is the seniority, in
And
that case, my lord,
you need not have to take an instruction from the department for that. What does E say, what does F say, and what was the resolution adopted? This will speak.
yes,
No further clarifications from anybody. Tuesday?
my lord.
Is Tuesday okay?
Yes,
Maybe, Lord.
But they have stated, my lord, by way of in I, they have stated that in case of the Lahiri, who has been recommended for promotion against RP number 5.
That is what we are saying. It is clear, but because to some extent we have taken Mr. Gogoi off guard,
I have no.
we are giving him that opportunity.
File a additional affidavit, which starts from page 340. My lord, I have stated, if there is a press division.
No, that will be a natural consequence if they are required to redo 422023
my lord.
without a reference to the roster point. Even then, we will not stop you. But it has to be without reference to roster point because it's a 5-post cadre. Take away clause F. Go ahead with the DPC. He gets it. We are not concerned.
Then
Whoever
there has
is
to be
senior,
reconsideration
whoever
again.
is senior, he will have his objections on the final gradation list, or maybe he will have one now. If this is the final gradation list,
Yes, now my lord, petitioner is above the.
then the petitioner has to be considered. Number one, being the senior, he'll be in the zone of consideration. Number two, his ACRs not being there is not his fault. He was not taken into consideration only because there was no ACR. Can the DPC do that? Then the person who did not forward the ACRs, he should have faced a disciplinary proceeding because it is not done.
I understand.
Lords, to that effect.
It is not that ACRs were not written, ACRs were not placed. Is it not malafide in law?
That effect, my lords, there is one contention, my lords. We have also made our point, if I may, my lords, for a moment. Lordships, there is an observation by the department itself saying that he did not pass the department examination till the date he has not fulfilled the eligibility. That is
If he was not eligible in 2023, so be it. The department will have its own reason.
Lords, that is
Your consideration in that DPC is under question. RP5.
Roster point number 5, lords.
Could there be a roster point? Could there be a roster point is the only issue.
Lords. Whether the roster was
Following Rakesh, could there a roster be there? Rakesh Agarwal says no roster point. It has to be done simply on merit or seniority or whatever is your criteria. You will not give anything more to a reservation. You will not talk about reservation at joint commissioner level. That is what we understood.
That is what merit above the rank of deputy commissioner, it has to be merit based.
Now, they are saying that it's a 5 roster point. Therefore, you come in, is what we have understood. We may be wrong in understanding.
I may be wrong, lords. But to my understanding of R.K. Sabharwal, lords. Lords, I'll just please,
R.K. Sabharwal was not. We would have gone into R.K. Sabharwal if that was what the this promotional committee had taken into account. They took into account what?
18/1/2023.
They took into account Rakesh Agarwal. They did not take into account R.K. Sabharwal.
Well, then that would be a count of contention for
What?
me. Lords, should challenge that of DPC.
Go and challenge it.
That is what.
Go and challenge it.
That is what.
Then you challenge your own selection.
Lord,
Go
that
and
is
challenge it.
I'll have to be.
Happily go and challenge it. You did not. You accepted it. You have defended it. You have defended it. Now you will not challenge it.
Lord, that
See,
was
the mouth
using
can
the
only
remains
blow
of-
hot or the mouth can blow cold. That is the only point. If the roster point was allowed and you were considered, nothing wrong. If it could not, if that clause F is overriding the judgment, and the person who got the order being a member of that same committee is allowing that to happen, what can we say? Mr. Rakesh Agarwal is one of the members, is he not? He cannot hide behind the, what do you call, veil of the committee.
The lifting of the veil has to be there.
List this matter again on 17th of March. Allowing Mr. Gogoi, Learned Additional Advocate General and Standing Counsel, to have his instructions on the limited query raised by this court. Stop.
We will clarify that point also, my lord, so that I can convey to them and have a specific instruction on that. For otherwise, my lord.
The Learned Counsel for the petitioner has pointed out that as per clause E, paragraph E of the office of the DPC held on 4/2/2023 has been sought to be overridden by the contents of paragraph F of the same DPC, full stop. The Learned Additional Advocate General shall have specific instructions as to whether the roster point had been applied during the DPC, overriding the judgment of this court in the case of Rakesh Agarwal. Stop. Since the matter is being fixed on Tuesday, on 17th, the respondents will not proceed. No, the interim orders passed earlier regarding the promotion of the respondent number 5 not to be given without respondent number 7 not to be given without the permission of this court continues till that day.
The citation is 2016 3 GLT 464.
Rakesh Agarwal.
2016 3 GLT 464.
And with what has come today, that gradation list, you have a round of litigation.
But that list, my lord, can I retain it?
Oh yes, yes. Instruction I dismissed, I disposed. I order. I last line to I. Since the repetition has been fixed on so and so, the interim order continues. I disposed, huh? এখন এতিয়া কি দিছে?
I'm obliged.
Hmm. Nine one.
I was asked to submit a PPO of my father. Which I have submitted. How can we close this case? Yes,
Now, has she got the relief? Then how can we close the case?
No, it was, there is no objection regarding her pension and all lordship. They are directed to submit some documents to the treasury officer. Then she says she has submitted.
The pension has not yet come. That is the problem. When did you submit it? Yesterday. We'll keep it at the end of March.
My lord.
No, not at the end of March. We'll keep it on the 9th of April
Lordship.
or 10th of April.
My lord.
In the month of April, the pension should be there.
My
If it comes into the account, we
lordship.
close the issue.
Lordship.
So I don't think in the interim they are going to give the pension. They'll give it only in the first week of April. The learned counsel for the petitioner has submitted that both the halves of the PPO have been submitted to the treasury. Full stop. The learned counsel, Ms. D. Bora, learned counsel appearing for the respondents has submitted.
MD Bora.
MD Bora has submitted that since the documents have now been submitted, the pension should start at an early date. Accordingly, list this matter again on the 10th of April, allowing the councils to apprise this court regarding the status of the payment of the pension.
Lordship, I am appearing for Transport Department.
Transport
Accountant General, someone is appearing. They will get the instruction.
10th of April, we are fixing it. Kindly tell us that the pension has started.
My lord may kindly record. Otherwise, they will not get their instruction.
Yeah.
On last occasion, they have taken time.
Miss so-and-so appears for the Accountant General, who shall have specific instructions on the status of the pension. What? That you will not pay.
Lordship, that the PPO, the half of the PPO we have not received, Lordship. I have submitted.
He has submitted yesterday, madam.
Then Lordship, I'll have to take instruction from department, Lordship.
On 10th of April, tell us that the pension has started.
22.
May it please your lordship. Lordship, matter may be passed over for the day, lordship, as Mr. R. Sinha is lakes on court number 1, lordship.
He is doing a long argument. You are required to place something before this court.
Yes,
Have you? Oh, that is the.
Yes, the interim order is there.
No. Which Mr. Sinha is supposed to give us the?
R.
Both are Sinhas. Order says Mr. Sinha will give the information. Okay, Wednesday next. 18th. List the matter on 18th, allowing Mr. R. Sinha, learned counsel, to place the instructions required by this court earlier.
I am to be given.
Then give.
Yes, sir.
No. Give the instruction. You are required to say what?
That I am still working in the place of posting where I am there. I have been promoted matter, and posting has been given at Dibrugarh. So I select that from that notification.
You don't want to go to Dibrugarh?
The list is on 25/6/2025. The first promotional order has been issued. Subsequently, on the same day, another order has been by cancelling this one. So there is some changes in the place of posting. So I am one of them. That my posting earlier it was at Mangalore, but later on it was made it as a Dibrugarh. So the requisition has been filed. So now, my lord, what I pray now, my lord, the posting where my this respondent number 5, she has already joined, so I have no claim against her. Now my prayer is there. Some two more posts are there. I may be accommodated there. That's why I have filed. I have filed only for that. All representation is there. That's why you dispose.
You are appearing for respondent number 5. Where is Mr. Choliha? Did you create a scroll that you? Let Mr. Choliha be here. Yes, Choliha. Angus is Choliha. We'll have it after some time. Let Mr. Choliha be here.
Petitioner in selection process for the additional interval was called for the document verification on 9/7/25. He appeared and submitted all his documents, but his name is not found in the first provisional list. Then on the grievance list, submit the representation was found on the first provisional list, even after securing the highest mark for the last selected candidate. First question of list is lordship is at page connector 4, page 35 lordship. Last is 36. He is from the Bengali medium lordship. Last cut of mark is 69.051 in the Bengali medium category. And he secured lordship 60.85% mark, aggregate mark. Then in the grievance lordship, there was a for grievance redressal day, he appeared and submitted representation and submit again all his documents.
What do you say about the affidavit in opposition? You did not give any, you did not give the admission slip to the NIS.
Given everything.
NIS, where is it?
Section 10 or not lordship.
Page number?
43. There was a checklist lordship which was issued in terms of the Supreme Court judgment lord. One notification also issued which was not annexed to the affidavit in reply lordship. But I have the copy.
This is
Which is the requirement as per checklist. Now come to lordship page 44. This is the admission slip lordship. Then come lordship page 45. This is also admission confirmation slip lordship.
Did you give it to them?
No.
Yes, lord. During verification, I have submitted.
My lord, in the affidavits given, my lord, that he has not, he had not produced it during the time of verification, my lord. Your lordship
When a
confirmed
person
paragraph
has it
5.
with him, why will he not produce it?
This is the, my lord, if your lordship comes to paragraph 5, my lord, that while categorically denying the petitioner's claim of having submitted all mandatory documents, including proof of admission to the DLED course under NIOS, it is respectfully stated that during physical verification, the petitioner failed to furnish the mandatory admission records / admission slip of the DLED course through NIOS. In this regard, it is further submitted that pursuant to the judgment of the Honorable Supreme Court of India dated so-and-so, rendered in so-and-so, a notification dated so-and-so was issued directing all applicants who had successfully submitted their online applications on with the 18-1 DLED qualification from NIOS to attend the second phase of physical verification for proving their in-service status as on 10/8/17. The list of testimonials required at the verification stage.
Where is his rejection slip? From where this is being said, there must be some document, some record
I know then
that he had appeared on that day.
Lordship,
That there was a noting made that these documents have not been supplied. Where is that noting?
I'll get that in the form of an additional affidavit then.
No,
Because I
I
have
want
not,
that record.
I'll get it.
It is there in the affidavit. Why do I need an additional affidavit? I need that
If your
record.
lordship, you have given, I'll get the
I'll need the record.
I'll get the record.
May I submit lordship?
I'll get the record.
Whatever, kindly page 38. Lord. Even after publication of first provisional list, I submit the representation. Why my name is not selected? Page 38. No reply. Please check this lordship. Copy and close all relevant documents.
What are the relevant document?
This checklist.
How do you know?
Lordship, this is the notification which was issued by the department lordship, as per Supreme Court judgment.
There is one more aspect, my lord, which has to be pointed out, my lord, which is at paragraph 7 also, my lord. Apart from this particular non-submission of the documents, there's one more aspect which I need to point out, my lord.
Yes.
That in addition to the petitioner's failure, paragraph 7 of the affidavit, page 70, paragraph 7.
Just a minute.
Page 70. That in addition to the petitioner's failure, to submit the mandatory DLED admission slip, it is further submitted that there was also a mismatch in the petitioner's name as reflected in the UDIS records, thereby preventing verification of his service particulars and eligibility. It is further stated that the entire recruitment process pursuant to advertisement dated 26/12/23 has already been completed on 9/11/25 and all so-and-so posts have been duly filled up through a transparent and merit-based process. In such circumstances, no relief, my lord, much less any direction for appointment can be granted, my lord. That aspect also is there, man. The lordship has concern. I'll bring the record, my lord.
How I came to know what is the document? That's stated in the affidavit.
What is your name in the UDAS? You have a UDAS?
What is still, Lord?
You have a UDAS? Where is it?
45.
Page 45. Yes. Page 45 is National Institute of.
Open schooling.
Ah.
That's what it mentioned.
No, no, in your DIAS code, there is a mismatch with your name. What is your name in the DIAS code?
The name is Gauhati seal is correct. The school has.
Is this is the DIAS code record? Page 45? No.
No.
Kindly show us the DIAS code. DIAS code is not available to you. The details of the DIAS code would not be available to you. You worked in some school. You worked in some school. In that school, UDIAS, your name was there. They are saying that that name in that UDIAS. What is 62? Huh?
There is no silence, nothing.
Very well. No, we are not on that, sir. We are saying that UDIAS, your name is not matched. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. A. Fukan learned standing counsel, Department of School Education.
Elementary.
Representing the elementary education department. The affidavit in opposition has been sworn on the basis of knowledge by the director of elementary education, whereas references have been made to records on the basis of which the petitioner's case has been allegedly rejected. On the next date fixed, the respondent number 2 shall cause the production of the records of the verification process with regard to the case of the petitioner, showing the reasons noted by the verification committee for rejecting the case of the petitioner. Further, the respondent number 2 shall also cause production of the record on the basis of which it has been alleged that, where is it?
Paragraph 7. Paragraph.
Mismatch in the petitioner's name and the used DIAS records has been stated. In the absence of record, the respondent number 2 shall depute a responsible officer to explain the circumstances to the court. List again on your choice.
And after 2 weeks needed.
Your choice. Pick a date.
uh, 31st March.
31st of March 2026.
The tribunal.
Have the record, sir.
Well, I'll get it.
And also have one of your friends also in this room, because sometimes you are not here and no one represents the school education.
No, I'm here.
36.
The last order, my lord, one query has been made by the court, my lord. The present status of the petitioners, my lord.
Let an affidavit
My
be
lord,
filed.
that is why, my lord, the instruction has not awaited from the district district chief executive officer, my lord.
Should he come?
That's not, my lord.
Should he
So, sir,
come?
sometime, my lord.
Huh?
Sometime may be granted.
He takes more than a month to tell you that, okay, we are furnishing the details. Huh? Oh,
Because
the
rest
Joint
of the
Commissioner
case-
wakes up late, huh?
My lord, rest of the case, we will argue on law points, my lord. Only status of the petitioners, that is very important, my lord. That is why sometime may be granted, my lord.
No, you cannot simply go. Okay.
We have reconstructed the file.
By the order dated 22-2026, this court has observed that the matter has been pending from the year 2017 and no response had been filed by the concerned respondents, full stop. The order had required the respondents to file an affidavit incorporating also the status of each of the petitioners as to whether they are still continuing in the PRIS. Full stop. Today, a instruction has been placed before this court issued by the Joint Commissioner of in the Office of the Commissioner PNRD Assam, issued on 9/3/2026, requiring the Chief Executive Officer, Nalbari Zira Parishad Nalbari, to furnish the status report of all the petitioners in the prescribed finance department format and submit the same to the Standing Council within 3 days from the date of issue of the letter, full stop. When the matter is fixed on 10/3/2026 as per the order dated 2/2/2026, this court finds it distressing that the Joint Commissioner issues a letter on 9/3/2026 asking for status report to be submitted within 3 days, comma, obviously, beyond the date on which this case is fixed. At the request of the learned Standing Council, comma, list this matter again on
After 10 days, my lord.
27th
My lord.
of March, by which time the requisite affidavit shall be filed by the respondents.
Okay.
Full stop. Failure to file the affidavit may lead to coercive orders.
Highly obliged.
Yes.
My lord, last occasion, they took time to file rejoinder to, but not file. I have not received any. The petitioner service was dismissed.
What is the ground of
After-
challenge?
Dismissal order from service manager. That is dismissal order passed on the pursuant to court of inquiry and on the ground of biogamy minor.
Double marriage.
Double marriage. After 3 months, he married the complainant.
First marriage and thereafter within 3 months another marriage.
Within 3 months, my lord.
Some brave person,
But,
huh? A lot of courage.
He was not agreed, but on the pressure of his family, he married him.
Twice.
Married her.
And then you are now
live with her for one month, and thereafter.
And then now you are again pressurizing him by taking away his job.
No, after that.
Give some other punishment. How will he maintain 2 wives? With a job, it is difficult to maintain 1 wife. Without a job, he is supposed to maintain 2. None appears for the petitioner on call. Affidavit in reply has not been filed. List again in the month on 18th of May 2026. 18th of May. Mr. A.K. Dotto, Learned Counsel, appears for the Respondent Union of India. Yes.
18th of
May.
29.
Yes, madam.
Supposed to get instruction.
Who? Mr. Soliha was required to
Lordship, here,
assist.
Lordship, I have been informed, Lordship, I have also placed the name of the petitioner has been in the approved list, Lordship, eligible
Okay.
list. But some time will be required because there are 1200 names, Lordship. So her name has been, the petitioner's name.
We
has
will
been-
say that you have informed the court that the matter is under progress.
Yes, Lordship.
And therefore we'll list it in April after
Similar
the
matter-
Bihu. Mr. H. Oliha, who was requested, who had appeared on behalf of the contender number 3, has informed the court that the case of the petitioner is under consideration along with around 1200 petitioners are under consideration along with 1200 other
Yes, Lordship.
employees. Stop. Accordingly, he has prayed for some time to have an updated instruction. Full stop. Place this matter again on 22nd of April.
Lordship.
Mr. Soliha shall have his updated instructions. You are appearing for?
On and 1 and 2 on behalf of the.
So and so appears on behalf of the respondent number 1 and 2. Madam appears for the petitioners, huh? Madam, why don't we adjourn the matter sine die? Have you heard the word sine die? No. We'll adjourn the matter till a date when you mention it to come up on the board again. No, what you are saying is, time and again, requests have been made not to take up the matter. How long will this go on? 2021, matter is adjourned for petitioner. 2025, thereafter 4 years, you do not touch the matter. In 2025, it comes up again, adjourned. Again, adjourned. Again, prayer of counsel adjourned. Again, writ petitioner adjourned. Again, citing difficulty adjourned. Again, August adjourned. Again, February adjourned. When? We'll accommodate you till 17th of March. At the request of the Learned Counsel for the petitioner, list this matter again on the 17th of March. It is noted that the matter has been repeatedly adjourned at the request of the counsel for the petitioner. Yes.
56.
Previously, we are praying for a benefit of a judgment of government of the minimum fee.
Minimum?
Wages.
Why don't you give the minimum wages?
Lordship, starting Lordship, may I point out one thing, Lordship, in a similar batch of petition, Lordship appeared in earlier petition, that Bartak Labor Union case, Lordship. So, Lordship may like to.
Then I will not be able to take up. Oh, yeah, Bhatak Labor Union is here.
That case is that there is a pair of regular, we are not paying.
Huh?
But there is a pair of regular, so we are not paying for it.
Yeah.
We are paying the benefit of that.
They are seeking temporary status, but I'm going to rely on that judgment also that you can, just Honorable Justice, you can have judgment also, Lordship.
Saying what? Yes, sir.
If Lordship take
Something I was told by this court that I am wrong. You are asking the same benefit from me.
No,
Not the same benefit.
They are not the taking order. Lordship will find.
No, can you deny minimum wages to anybody working
minimum
with you?
wages we are not paying. Minimum wages they are paying. They are getting minimum wages, Lordship. They are.
No.
They are get-
6,500 we are getting.
Have you seen the vehement movement of head from side to side? They are not getting it. Where have you stated that you are paying them the minimum wages? Petitioners are being paid lump sum monthly wages at 18,500. That is at para 21. What is your reply? Hmm?
By this petition, I have stated we are getting 80,500 per.
And that we have seen. That is what we are
There are
asking
eight
him.
lordship of my affidavit lordship.
What are you granting them?
Lordship, there are 8
Tell us.
lordship.
Tell us.
They are getting minimum wages lordship.
Of?
As per norms lordship, that is lordship.
What is the norm?
That is lordship.
What is the norm? Para?
Para 8 lordship of my
At
affidavit.
which page?
121.
Yes, the daily wages are fixed in consultation with the local authorities, and such wages are not less than the minimum wage fixed by the state government from time to time under Minimum Wages Act. This was filed in the year 2000. What? Writ petition of the year 2021.
Lordship.
What is the minimum wage in 2021 and what are you paying them?
Minimum wages relating
That-
to the lowest wage of employee minimum. That was cleared in job fixing scheme. Of a regular employee. Of a regular employee. Not in consultation with the state.
Lordship, as per my instruction, lordship, that query I put to them also, lordship, and they as per their answer, lordship, they are paying it as is minimum wages are in state-wise different, and they are paying it.
That piece of document, this is what is told to us by the state government. This is what we are paying.
Lordship, that is
Why does that not come up? When you say you are making a good affidavit in opposition, you are typing it out and giving to the court, is it not? When he says it's a good writ petition, he's typing it out and giving it to the court. Why don't you give it to the court in writing? That this is what the state government says, this is what you are paying. Finished.
F. This is not. It was not annexed along with the petition, affidavit, but that copy I have.
It is annexed.
Not annexed also. The state-wise, it is different.
You are giving us a copy of the Ministry of Labor and Employment notification. What does it mean to the petitioners is what we want to know. That
Automatically fix it day after tomorrow. I will.
what is it? Are they under the unskilled, under semi-skilled, are they under skilled, clerical, highly skilled? What are they?
Regarding they are unskilled also.
Huh?
Most of them are unskilled.
Unskilled. What do they do? What are your job profile? What is your job profile?
Machinery. All machinery company.
Semi-skilled.
Yes.
At the minimum, semi-skilled. When? Only if you file an affidavit, they will come to know to that effect. Simply denying and saying that no, we denied, we are giving them the wages.
Then we can file one regarding that.
The Learned Council for the Learned Central Government Council has prayed for an accommodation to bring on record the wages being paid to the petitioners, since it has been alleged that the petitioners are not being paid the minimum wages in accordance with law, full stop. How much time would you require? 2 weeks. We'll have it immediately after the Bihu vacations. Let the affidavit be filed within a period of 2 weeks. Yes?
Some of the similarly situated employees
Uh,
being granted temporary setup. We are not asking for regularization. Some of
The-
those documents that I have enclosed in the report.
have you denied it?
Lordship.
You have denied it, that
because
they are not,
They have been engaged for 6 months only. And for temporary status, they have to be engaged for 1 year at
that
least.
one day
They will
break
have
in between,
One break.
1 day break in between, taking away all
One
the
day.
rights. Is it not?
My God, I have
They are
enclosed
role,
their document.
role model employer, sir. Mr. Chanda has submitted that similarly situated persons have been granted the temporary status, which is disputed by the learned CGC, Mr. Lokor, by stating that such persons have only been engaged for a period of 6 months, giving 1 day break in between to ensure that the temporary status is not made applicable to them.
So 2011, from Jammu Kashmir, they went to Supreme Court. In that case, my lord, Supreme Court dismissed the SLP, where temporary status was rejected to be given, and accordingly temporary status was given. They should also indicate in the affidavit whether
Yes.
it's person or if.
Whether the affidavit shall also indicate whether temporary status to some of the employees similarly situated as the present petitioner had been granted on the basis of a judgment of the High Court of Jammu and Kashmir, which is relied upon by the petitioners.
I'm being at item 22.
Yes. Hmm.
That's what I'm. That, your lordship may kindly look into my daughter. Page 23 of IM.
No, we were waiting for the health department.
Yes, Madam, he was there.
Yes, some tussle between the petitioner and the respondent number 5 regarding a certain posting. Now, the petitioner is giving up the tussle with respondent number 5 since he has joined.
Yes, Lordship.
Why don't you accommodate him somewhere else?
Now, Lordship, from what I have understood, she is already working somewhere right now.
Ah,
And if what is if that current posting there is no grievance, then where if my learned friend Lordship, I'm just talking with the authorities only.
uh-huh.
They are trying to find out. I just want to find out that she is currently where she is working. If there's any dispute regarding that.
No, currently I am working in my original post. Ma'am.
If you are allowed to work there, there is no problem.
No, because this is a promotion. I have been transferred or promotion. So if I allow to work there.
They will take away the transfer. They will keep you on the promoted post. Are you happy then? Yes.
Lordship will just.
Can you find out?
Yes, I can.
Monday?
Find, Lordship. Monday.
I have mentioned
Because-
there are some posts, but
Not on the post you are now currently working. You don't want to work there.
Yes.
And list this matter again on what is Monday? 16th.
Lord.
Allowing Mr. Soliha to have his instructions regarding the proposal made by the learned counsel for the petitioner
Lordship.
for a different place of posting,
Lordship.
including the post where he is currently serving.
Yes, because the department is also not taking any action. Lordship.
Bring it on Monday. Duke, what about the updates?
37.
Yes, sir.
Yeah,
Hmm.
the present petition basically challenged his professional post, which was denied to him, but considered the respondent of 7 here, junior to the present.
Hmm.
And on the basic, present petitioner was joined in the year 2009 as a junior engineer, though he has the Bachelor of Degree in Engineering department. But the respondent authority denied the promotional benefit to the present petitioners as per their law that those persons who already appointed as a junior engineer and after joining, if he completed his bachelor degree,
then he will be qualified. And those candidates, he had not, already he has the bachelor degree, and if joined in a junior engineer, he will not be allowed to get promotional benefit. That is the issue, you know.
You are appearing for?
Respondent number 7, Lordship.
Take your seat. You are appearing for the government member?
Lordship, we.
Very strange proposal.
And the
If you are qualified when you join, then you will not get a promotion. If you have taken the qualification after you have joined,
This is
you
the
will be.
rule, Lordship, that.
Huh? Wait, show us the rule.
Rules.
Yes, Lordship.
Very,
as
very
to
good
town
rule.
and
Yes,
country
Lordship,
planning.
that's the problem.
Where
Yes,
is the rule?
Yes, this is Lordship.
there's the hurdle, Lordship.
And you have not challenged the rule.
The rule has not been challenged, then this is the main thing.
Ego lucky.
in this
Lordship, actually,
relevant judgment, it is a covered case earlier judgment also. My lord, may kindly peruse at the additional
7-3.
affidavit filed by the present petitioner, my lord, in this case 5 to 7.
7-3, Lordship.
What additional affidavit?
Assembly.
One affidavit only.
Yes.
Sorry.
Yes, where is that part? And
7-3, Lordship.
7-3.
Yes.
no, which rule says so?
7-3.
Clause 7-3, Lordship, of this. Act.
7,
Clause 3.
member of the Assam so and so. This is planning assistant.
Town and country planning. Lordship.
Provided not in engine content herein before in this rule subject to suitability. A junior engineer on acquiring his academic qualification as prescribed in a direct recruitment.
Lordship.
Eh?
Lordship, the departmental note, there are so many departmental notes, Lordship. Explain this clause like this. Lordship, the candidate who acquired the degree of bachelor during his service period.
Only he will be allowed to be promoted.
Yes.
And a person who already has that
Yes, Lordship. During his
qualification.
service period with the permission of the concerned department will only be eligible for the promotion of direct recruitment. This is the
Against all logic, you are trying to explain a rule. It is a yes.
rule.
Where is the judgment?
Kindly may peruse at page 68.
Page?
68.
Ah,
Not in the writ petition, affidavit filed by the present petitioner.
then you should have your records correct. They are paginated serially. So it is page 118.
The laws.
This is 11(4)(c). The same condition was there.
My lord.
This is
And
another
similarly
department,
situated,
not the same department, Lordship.
Similarly category case.
Oh, yes.
And it is a covered case in law.
Yes, madam, have you gone through this?
And already it was a.
What we are also understanding it in the same way. Anybody who acquires the qualification while in service with the permission will also be promoted. The persons who have the degree before joining will have to be promoted.
Lordship,
And those who acquire it during their service
Lordship.
with the permission of the
Department.
department will also be promoted, and for them it will be a direct recruitment.
Direct
Yes.
recruitment to this, Lordship.
So now once for them it becomes a direct recruitment, for whom is the promotion meant? For the person who already had that degree when he joined.
Yes.
Only for him it will become a promotion.
Joining, that doesn't, because the post he joined, this qualification was not required, Lordship.
Maybe, but he had the qualification.
He had the qualifier, but
Then-
it was not informed to the concerned department, Lordship.
So this is the main.
That
thing,
is not the
Lordship.
reason for denying him the promotion.
Yes, this is fact.
Yes, sir, you let
Yes.
madam do her
Yes,
part.
Lord.
How can you justify a departmental action? She has to do it. Yes.
Lordship.
Have you seen that judgment which has been annexed by him?
No, Lordship, I have
Okay.
not gone through this, Lordship.
Crux of the
This
judgment is,
Lordship,
if you come to page
68.
68, no, I'll take you to the main portion. Page 69, para 4.
Lordship.
It is submitted by the learned departmental council. The promotion to the higher cadre can be considered only for such junior engineers who acquired a degree qualification after their entry into the service. And as such, promotion cannot be considered for those who have acquired the graduate engineering degree prior to joining the service. Is this your submission? Then, if that is so, we are not reading the whole judgment. We will just come to paragraph 12, sub-para. Okay, you do it. You do it. Please. Para 12, sub-para.
Keeping it.
Page 1 to 3.
The explanation furnished by the department cannot, in my view, is acceptable as no corresponding change in the rule has been incorporated to do away with the long-standing practice followed by the department. There is really no basis to make a distinction between those who required higher qualification and they joined service and those who joined service in the lower cadre with additional higher academic qualification. Therefore, non-consideration of the cases of the petitioners for promotion under so-and-so, so-and-so, so-and-so.
Anna?
Yes, Lordship.
So it boils down to that those who have already got the degree when they joined,
Yes, Lordship.
for them it will be a promotion.
Yes.
For those who acquired the degree later on and then gets promotion,
Almost
for
similar
them
to
it will
the
be
present case,
it
Lordship.
will be a direct
Yes, Lordship.
recruitment for them.
Lordship.
It
Then
will not be taken as a promotion.
one thing that has to be taken because as the qualification required while he entered into service, the post he was.
He might have had a higher degree.
Lordship, just want to whether he disclosed this because subsequently it was also seen that he acquired MTech also.
Huh.
This is also
MTech?
there.
Then there is that other judgment of the Gauhati High Court that if he takes the degree with or without your permission, he gets the benefit of the degree.
Definitely, Lordship.
Then-
But while at that time, whether before making entry or that means making application,
Have you
whether he suppressed these things, Lordship,
your-
and subsequently he
have
will
your-
come up with this also has to be.
Have your records?
Yes, Lordship.
Have your records, but
Yes.
because is that the ground for not allowing him to
Yes,
participate?
Lordship, understood.
Respect to submission is that the present petition was not violated the advertisement rule,
Huh?
when he was applied. As per junior engineer recruitment and he was freely applied,
Did you hide your qualification is what she's asking. If you were a graduate and you did not tell the department that you are a graduate, you might have been overqualified. Is it not? That is what she's saying. When will you have the information?
Lordship, can you 1 week time?
26th?
Lordship.
26th of March,
Lordship. Lordship.
allowing the additional senior government advocate to have instructions on the queries raised by the court.
Deeply.
We are not writing a long order, we are not being
Lordship.
able to.
Yes, Lordship.
Who orders on for hearing Nikita? It orders, yes? You have the records, madam?
Yes, Lordship.
You have the records. We'll keep it on Tuesday next,
Tuesday, yes.
maybe 17th
Yes, Lordship.
or 19th.
17 also.
17th. At the request of the learned counsel for the petitioner, list the matter again on 17th of March. The learned counsel for the respondent shall retain the records.
51.
This case, this is respect of the, initial date of birth was 56, my lord. In 1256.
There is already an order saying that it will require a full-fledged hearing. Not today. Thursday? We'll have it on 26 or 19?
19, my lord.
19. Yes,
26, Lordship,
26.
26.
26, let it be 26. List the matter again on 26th in the hearing column. Hmm.
They are the homeguard, and they were discontinued from the service, from the department where they were initially working.
Hmm.
The homeguards normally they have, the certificate is issued, every 3 years the certificates are renewed. While they were working at the office of the Deputy Commissioner of Police, they were issued the order of termination by saying that that is what is included in page 43, the word used by authority is terminated.
Hmm.
Whereas the authority was issued, the order is not the appointing authority. The appointing authority is the Home Guard.
Director of Home Guards, yes. Yes.
Affidavit lordship, what we have mentioned, being
Huh.
homeguard lordship, they have already completed 6 months period.
Huh.
And secondly, lordship, if lordship see from page number, lordship, I'm coming to that authority part, lordship. And secondly, lordship, if you see lordship, page number 50 of the affidavit, all the petitioner, petition number 1, petition number 2,
Hmm.
against everybody, lordship, there is one or another criminal case is pending. Discharge as he was involved in
No,
some
this
job.
then if that is so, then this order is wrong. You are saying that page number,
Page number 50.
no, page number 43, he challenges. He is challenging page number 43. Is it?
Yes.
There you are saying that because 6 months is over, therefore we are terminating. And now you are showing us page 50 that these people were involved in some disciplinary proceedings.
I mean,
It has to be either. It cannot be both.
one thing is that all the crimes cannot happen at the same time, lordship. They are already being involved in one or another PS case, lordship. And another thing, lordship, they have also completed, as a together, they have completed 6 months period.
Okay, then what about the authority part?
Then in regard to the authority part, lordship, I need to take specific instruction in regard to that because our affidavit is not covered.
19th. Let him have his instructions. We are listening a little bit and we are trying to fix it up on particular dates because we know what we are arguing on that day. Is it not? His cases, not the authority, cannot be terminated. Huh.
If there were any allegation, they should have.
Okay.
To notice,
Without that, they cannot do both.
No,
You can do either. You are bad people, go home, or your contract is over, go home. How can you do both?
We are not taking the help of all these lessons, but only thing is that they have yes.
They are very bad people. We don't mind that. But tell us the authority under which you have done it.
That instruction I'll get.
Is it not? If they need a disciplinary proceeding, this is the last court to interfere. In a discipline force, no indiscipline. Is it not, Mr. Gupta? Yes. He agrees.
Yes, I understand.
We'll keep it on 19th. Okay. List for hearing on 19th. At the request of the council for the parties.
Finally, there is the last order. Directed to the instruction.
Yes, sir.
Yes, Lordship, I have inquired from the respondents, my lord.
Huh.
The part of the claim of the petitioner, we are not admitting the entire claim, my lord.
Huh.
The only gratuity and leave encashment was paid partly, my lord. That too payment we are admitting, my lord. But
Paragraph 7 of the writ petition says what?
There is a list of the
Leave
claims.
encashment have you paid?
Leave encashment partly it has been paid.
Now, when are you going to pay the rest of it?
Also, we have stated in or affidavit.
You, which are the things that which you cannot?
Lordship, may kindly turn to page 36 or affidavit, my lord.
No, we will not go for a long hearing now.
Reply to 7 is in page number 30.
Huh?
Reply to page paragraph 7 is at page number 30.
30.
You enclose the short in page 36, my lord.
Why are you worried about this Syed Nazrul Islam?
Actually, my lord,
How can you do that?
Lord, what had happened?
Banks cannot do it.
At that time, he was the superintendent of that particular center, my lord. While being the superintendent, he has misused his position and he has taken the loan from the.
So that misuse has to be proved.
Yes, my lord.
By what means? Either a case
by
or
entity, my lord.
Can you ask it of him? No. Nazrul is not asking it of him.
No, he has given us a complaint, my
It
lord.
doesn't matter. There are different judgments of this court, which
In
says
the-
that even the bank, if the bank requests the employer that he owes me money, give it to me, the employer cannot.
Yes, my lord.
Then how can you do it?
Now the admitted amount, we are trying to make the payment, my lord.
That is what we wanted to know on the last date.
Yes, my lord. Not, as because the corporation, they are having some difficult times, so in the month of March, they won't be able to make the payment, my lord. So
Hmm.
they what they requested me to inform your lordship that let the case be pending. Your lordship may kindly fix it at the end of April. In the meantime, they'll try to make the.
Yes.
We'll inform the
My
court,
lord,
my lord.
Lordship, may kindly come to page number 24. Similarly situated employees, my lord, they have earlier approached the court and they have already benefited, my lord.
They are not saying no. They are saying till April. Even if we have the entire office standing here, sir, this is money matter. Can they pay? From where?
Because of they are taking it very lightly, that is the information.
Heard Mr. S. Dr. Leonard Counsel appealing for the petitioner. Also heard Mr. S. Counsel Leonard Counsel. Corporation Department.
Yes, my lord. I'm appealing for respondent of 2, 3, and 4.
Sending counsel is there, my lord. But today,
On behalf of SK
Okay. The Leonard Counsel appealing for the respondent number 2, 3, and 4 has submitted that the information required by this court would be placed within a period of 6 weeks since. Now it is March ending. Full stop. Since in the month of, I don't say March ending, since in the month of March, the department is the respondents are facing a financial difficulty. Full stop. Accordingly, list this matter on the 28th of April. 28 April.
Yes, ma'am.
By which time? On which date the respondent number 2, 3, and 4 shall inform this court regarding the queries raised on the earlier order, failing which the respondents may be required to be present in this court to explain circumstances. Unless you have it in April, they are coming to the court. Yes. Yes.
my senior, I reckon, was present in the morning, but he will certainly hold the duty of his paper.
When do you want it? When can you have it? Not tomorrow, day after
I
tomorrow.
think lordship, this will have to be after the Eid, and most probably due to this, I think he has left. That's
Huh?
due to this Ramjan, these things.
Then we'll keep it on the 24th. 24th of March. At the request of the Learned Council for the petition list again on the 24th of March.
Deeply obliged.
Yes, sir, records.
Yes, madam.
Hello. None to contest you.
Madam.
Saved by the bell.
Yes, madam. This Ramzan month is going on.
I'm saying saved by the bell,
Yes,
4:15. School bell it is ringing and then no class. Huh?
One good news for the petitioner. One good news for the petitioner.
Yes.
I have received a letter today, madam, wherein my lord, provisional pension has been granted.
Mr.
Can you produce this letter, madam?
Mr. Espidat Lanet, Standing Council DENCT submits that the provisional pension has been sanctioned to the petitioner. Full stop.
As per letter that 7/3.
By the order dated 7/3/2026. Full stop. Yes, your provisional pension has been sanctioned. List the matter again on, we'll have it on the 10th of April. For the petitioner to inform this court whether the provisional pension has been received. Yes, 10th of April.
Obliged, Lord.
Attendance ले लीजिए. Your name, madam? R. Datta. Allah cranial. R. Datta. अच्छा. R को common रखिए, Datta and लकड़ा रखिए. Yes, item 47. List this matter again on the 17th. 19th. 20. After 27. Then it will be on the 6th of April. On the 6th of April. Allowing the respondents to file the affidavit sought for.
48.
Yes, sir. (26) List again on the 26th of March.